uh, 877 number, and also to hang up from the participant number and the participant passcode number.
All my bags are packed. Well, I have the car.
wonderful to be back in Gunnison. I spent one of the best years of my life here. I spent all of my time fishing and hunting and wrestling, and then realized they didn't offer a degree in that. So I tell people I'm one of the few people I know who had to go to Boulder to settle down. But it's a wonderful place, and it reminds me every time I come back why the Western Slope is so special. So, Mr. Chairman, I have very few things to cover this morning. Pleased to announce that we're making real progress on the mines in Moffat County. The Trapper Mine revised plan has been approved, complying with Judge Jackson's order, and then the Colorado mine has been approved. The Trapper Mine has been given an extension until April to get their plan revision in place, and they can continue to operate. So we are doing everything we can to make sure that those jobs are protected in Craig, and that incredibly important part of their economy is allowed to continue. We continue to monitor the animus, the unfortunate incident that we had on August 4th or 5th down there when the orange plume was let loose from the Gold King mine up above Silverton. We are monitoring the work being done by EPA and offering whatever technical assistance we can provide based on our mining experience. There was a congressional hearing last week. There are actually 2 this week in DC as the congressional folks are hearing from officials with EPA and the contractor and trying to determine what happened, and most importantly, how we make sure that this never occurs again. DNR is participating after the fires in South Fork a couple years ago. The local folks got together down there and created what's called REACT, and it's a consortium of private and public sector folks who understood the immense challenges that occur in a post environmental disaster scenario, and they came together to do 2 things. First, to figure out what their path forward was, how they could minimize the impacts to the water quality from sedimentation, and then also what could be done to make sure it didn't happen again, to get more active on the forest and get the attention of the U.S. Forest Service. The similar model makes sense here because we have obviously a tremendous number of unreclaimed historic mines in the South San Juans, and this discussion is occurring again in that context of how do we minimize the impact of this, get the local economy so we don't see any long-term residue from the effects of this event, and also make sure that we are putting pressure on to get appropriate remediation of these facilities to once and for all do what we think is just kind of a no-brainer, and that's get Good Samaritan legislation passed where we can get a little more broader immunity and get some folks up in these mines and getting them cleaned up. So that's really where our focus is right now. It's a relatively quiet time of year. We're gearing up for the next legislative session. DNR has a pretty modest agenda for the next calendar year. It's going to be an election year, and things always get tough during that session. But I think we're ready to go and looking forward to a good fall and getting into the next legislative session. Mr. Chairman, I really don't have much beyond that. If there are any questions, I would be more than glad to entertain them.
Any questions for the executive director? I know the folks in the Animas River corridor very much appreciate the efforts of the state DNR and CDPHE and the governor's office coming down and drinking the water when it was appropriate.
What do you do?
But anyway, seriously, thank you very much. That was very helpful. I think everyone really appreciated that. Okay, Director Lepore.
Thank you, Mr. Chairman. Good morning, everybody. I'm going to go through the staff report a little bit more than I normally do, but there are some things in here that I would like to highlight. Beginning with the outreach efforts of the COGC staff over the last 2.5 months or so on the task force rulemaking, we decided that rather than the standard stakeholder process followed by formal rulemaking hearings, we should introduce a preliminary stage where we traveled around the state to meet. Our focus initially was with local government representatives to talk about this rulemaking where the commission is being asked to implement a process by which local governments consult with operators under certain circumstances when there's a large oil and gas facility proposed. We ended up doing 11 meetings throughout the state. Those meetings were attended by a total of 39 local governments. So I feel very good about the response we had to that effort. In addition to those 39 local governments, we met with an array of both environmental NGOs, citizen sort of loose coalitions, and industry representatives, something like 11 odd different stakeholder groups met with us apart from these meetings that we had with local governments. So it was a busy time, but I think an important time in terms of outreach and interface with the commission. And I hope it bears fruit as we move into the more formal rulemaking process. I do want to acknowledge the team that undertook that effort. Julie Murphy, our hearings manager, Greg Duranlo, our environmental manager, John Nato, our oil and gas location assistant supervisor, and Jen Bach, one of our hearings officers, along with Kathleen Stacks from the executive director's office, were just instrumental in all of those meetings. Most of them attended almost all of those meetings. Kathleen did a lot of the organization for making sure that those meetings actually came together. So my thanks to all of them, and we'll carry forward with the rulemaking. We do have, just as a reminder, we will have a rulemaking hearing on November 16th and 17th that will be focused only on the rulemaking, the task force rulemaking. That hearing was not on your calendars previously. It has been scheduled in as a special rulemaking hearing. On the subject of rulemaking, the noise rulemaking that we kind of had intended and hoped to run in parallel with the task force rulemaking, if you will, we have decided after consultation with a technical work group that Dave Coleman has been leading that we need to delay the start of that noise rulemaking a bit. We've been asked by industry representatives to give them the opportunity to gather additional data, and we felt that it was in everybody's best interest that we take the time now to do that and not maybe try to avoid some squabbles later about data. So we've been clear that we don't want to delay that unduly long, so we're not talking about a year delay or a 6-month delay, or frankly, I don't think a 4-month delay, but a couple of months maybe to allow some more technical data to be developed. We are about to embark on our third lean process in the last 2 years, really. Again, Deputy Director Coleman is going to lead that. We have hired an outside consultant to really run the lean program. This one will focus on our field inspection reporting. We feel there are some improvements that we could make internally, and interestingly, we have decided to invite industry representatives to participate in that lean so that we can hear from industry side what their issues are with the way the field inspections are written, for example, and lack of certainty about what we're asking them to do or why we think they're in violation and so forth. So do a kind of a two-way street on that lean process. We've got, I think, 3 industry reps on our steering committee, along with myself and others. And then they will also participate in the actual lean group. I just want to note, Stuart Ellsworth, our engineering manager, has been asked to participate with the University of Colorado on something called the collaboratory. Is that a word, Mr. Chairman?
You know, I noticed that word and I had never seen it before.
It comes from academia, so there's 50-50 chance at least. In any event, there is a collaboratory for induced seismicity that has received a grant from the National Science Foundation, and Stuart Ellsworth has been asked to participate on that committee, which I just think is a testament to Stuart's all-around expertise and knowledge.
Director, I'm assuming that that unit that's going to look into the induced seismicity is going to be looking other than certainly Colorado, although I don't think we have a huge issue with that in Colorado, but they're apparently, I'm assuming, looking at other states as well.
And I'll be honest, Mr. Chairman, I don't know the scope. It is being led by the University of Colorado. And if you'll recall, we worked closely with geophysicists from the University of Colorado on the Greeley incident a year or so ago. I can find that out for you if you'd like.
Well, I just,
Don't know.
in as much as Colorado hasn't had a great deal of difficulty with that, I just kind of assumed if they were going to have a study, they would have to look elsewhere to get some data,
Like Oklahoma.
like Oklahoma. I didn't want to say that, but like Oklahoma.
Right. All right. I definitely want the commission to be aware of this issue, which relates to what we typically refer to as excess inactive well bonds. Some people refer to it as idle well bonding. But the bottom line is that if an operator holds a number of wells in their portfolio that are shut in or temporarily abandoned, and those wells, the combined number of those wells exceeds the amount that they have with us in bonding, their blanket bond, then we ask them to increase the amount of their bond. It's a challenging price environment, as all of you are well aware, and we are finding that there are many operators in or near that need to increase their bond. So we have created a process internally with staff, really led by Martha Ramos, who is our bonding supervisor, to keep a watchful eye on operator status. And since June of this year, Martha has reviewed 64 different operators with this in mind, to look at their status with respect to wells that are shut in compared to wells that have been producing. That review of 64 has yielded 11 operators who have inadequate financial assurance at this time under Rule 707. So you think about it, it's sort of a double whammy to tell an operator in this price environment that you're under bonded. And you're under bonded because you've shut in wells and you don't have revenue stream from those wells. But that's exactly the position we find ourselves in. And so we have essentially sent warning letters to those 11 operators, and I believe 2 have now been issued notices of alleged violation. So it's a ticklish situation, but it's one in which our failure to act could leave us all feeling foolish and perhaps far worse once, if things continue to not go well for that operator. So mostly I want you to be aware of that and know that we are keeping an eye on it. We have had a very successful story with one operator who, I think these are rough justice, had operated something like 60 wells, but many of those had been shut in, and they would have had to bond up to the tune of about $500,000. But we worked out a plan with them, and they have been very aggressive in plugging some of those wells so that they're off of that list and so forth. So, I think hopefully it's a situation where a little bit of prevention can prevent a lot of cure need down the road. Commissioner Allward.
Thank you. I'm curious about this definition of excess being when the costs of plugging and reclamation exceed their bond. It seems like when we're claiming bonds on a single well pad, that bond is insufficient to cover the costs of abandonment and plugging and reclamation. So it seems like just one inactive well could be sufficient. How are you determining what is excess?
So first I would say that, and appreciate the question, honestly, in my mind, you're pointing to sort of a separate but related issue, which is the size of our bonds. And as you well know, the size is set by statute. And we don't do the math that you're suggesting when we identify excessive. I hope I get this right. If I don't, somebody correct me. But basically, we take $20,000 is the amount we assign to each shut-in well. So if you have 10 shut-in wells, that's $200,000. If your blanket bond is $60,000, you're under bonded by 140. Is that close enough for government work? Okay. So that's the math. That's the calculation. It's simply $20,000 per if they're shut in. So if you have 15 wells and 12 of them are producing and 3 are shut in, you're fine. If you have 15 wells and 8 of them are shut in and you have a $60,000 bond, you need to bond up. Commissioner Craig?
Question, looking at our fund for plugging wells, my real concern is some of the forecasts that I've seen for prices going forward are really scaring me. That there could be far more bankruptcies, which would put an awful lot of wells on our plate to plug. How is that fund, and have you looked at it to just get an idea of, you know, whether we are financially secure if we have to go ahead and plug a lot more than we ever thought?
Again, a great question, and you're foreshadowing some things that we'll talk a little bit later in today's agenda on, not necessarily related to under bonding, but in relation to operators who have been unable to, or elected not, I don't know which in some cases, pay penalties or perform corrective action. And they owe us money by virtue of an order from this commission. There are corrective actions needed at those locations, and I will be asking for the commission's blessing later today to take money out of the emergency response fund to perform at those sites very, I want to say, in short-term actions to fundamentally stabilize sites to prevent any sort of imminent or immediate harm from occurring. On the bonding, on the plugging and abandonment side, what we have is a line item every year allocated from the legislature out of our total budget. Currently, $445,000 is what's allocated, plus or minus 10 or 15, but it's right in that range. When wells go on to that list, they can be on that list for a while. We have been over the last several years performing 10 to 12 plugging projects. If it gets into large remediation, then needless to say, that can take a lot more time and money. So our focus is on plugging those wells that fall into our hands, if you will. And we try to prioritize those and, again, of course, take care of potential environmental impacts or safety, health risks. We do those first, and we do those as a high priority. Otherwise, wells can be on that list for a long time. And we could change that allocation. We could make some choices about how to spend the emergency response fund, although the legislation says you need to have an emergency to spend that money. So there are issues there. And again, we'll talk about them a little bit. I think a little bit on the executive session today, as well as later on these specific operators who we feel now it's necessary to take some actions and to use the ERF fund for that purpose. Okay, just wanted to highlight for everybody, the local government liaisons will be performing 3 more local government trainings through the course of 2015. One is right around the corner in Akron, Colorado, September 22nd, Weld County on November 3rd, and in our offices in Denver on December 1st. So local government designees who would like to phone up, please do so. Just a quick note on the Bureau of Land Management hydraulic fracturing rule. Some of you know that implementation of that order was stayed by a federal court. I believe it's now stayed into October sometime. As you also are aware, COGCC, with a very helpful hand from Kathleen Stacks at EDO, has been engaged with BLM to talk with them about a variance for the state of Colorado, that the BLM rules contemplated variances for states that have comparable rules. After many weeks of, I think, what we felt was positive engagement, the state office informed us that they their hands were tied, as it were, as a result of action from DC. So right now, all of those conversations are simply on hold. There seems to not, for the moment, while the litigation is pending, I think that was the main trigger. The headquarters has made a decision not to pursue the discussions about variances with states at this time. I think one more thing that I want to call to your attention, and that is courtesy of Deputy Director Coleman. We wanted to give you a little bit of an update on the complaint process. As you recall, we modified through a lean process first, the complaint process, and then Dave worked with others on staff to create a web-based interface for filing complaints. And Dave put together this report to bring you up to speed on how that has worked out so far.
Thank you, Director. Good morning, Commissioners. How are you doing today? I want to give you a quick update on the public complaint process, as Director DePore said. I'll make it very quick. So just to refresh memories, we kicked off a lean process improvement in October of 2014 with two main goals of that process. Number one, make the process more transparent and make it easier for the public to use. And number two, make it more efficient internally. We had a lot of internal headaches when we had complaints that were received internally here. So those are the two goals. The process went live, an interim process went live January 8th of this year. And interim, I'll tell you why I said interim in a couple of slides. So what we've done in that was create a dedicated web page for public complaints. So it's right out there on the front page. If you go to the COGCC's main page, there's a complaints page right off of it. And we designed an easy to use tool for complaint submittal with clear instructions on how to fill that form out. I believe it was Commissioner Allward that actually filled one out on his smartphone at one of the hearings that we were talking about this last time. So it still works. You can still use your smartphone to fill out a complaint. And we're starting next week, a week from today, we've now hired somebody to be the dedicated COGCC staff person for receiving, processing, and resolving complaints submitted by the public. So she starts a week from today. We'll be able to introduce you to her in the October hearing. So looking very forward to her coming on board. So making a complaint, well, one of the things we really try to do is make it a written process, not a informal on the phone. We wanted to make sure that we understood the issue and we documented the issue correctly, so we're not making any assumptions on what the issue is. That's the main reason why we wanted to make it written, and that's what this process was geared towards. Three main processes. This process is broken into three main categories, several steps under each one of these three. But it's basically intake and route to the correct technical people within the agency. Those technical people investigate and take appropriate actions. And then I think is one of the processes that we're lacking the most was formally closing it and formally communicating the results out to the complainant. So they're not just wondering, hey, what happened? What did the COGCC do, if anything? So that was an important process. So let's get into some numbers. Lots of people out here, I like numbers. Let's talk numbers. And these numbers are from January 8th when we rolled it out to September 8th. We've had a few more come in since September 8th, but they're not included in these numbers. So we have received 211 separate complaints, 270 issues associated with those 211. Some complaints could have multiple issues. It can be noise and lighting seem to be paired up quite a bit. So one complaint, but noise and lighting will be in that one complaint, and we investigate them both. 89.26% of the complaints were received by that newly developed online tool. That's probably the one statistic I personally am most proud of. So almost 90%. We were over 90%, but August just had a few do paper and drop us under 90. So we'll get back to over 80. Prior to the new process, most were received paper, or even worse, in my opinion, by phone, where we would have the phone in our hand and type in what we thought the complaint was in the form ourselves. Year over year, the number of complaints received, you could see we were in the 200 for the most part. Prorating the 270 that we received this year, we're on target to have 371 complaints received. Now the goal obviously is not to receive X number of complaints. It's never a goal of ours. We'd love to have less complaints, But you can see, we think the process and the added transparency is increasing it. 35% increase from the last year is what we're envisioning for this year if the rates are stay the same for the last few months of this year. So what are we doing in resolving them? So of the 270 issues that we received within those 211 complaints, 89% have already been resolved. So we've developed 2 metrics. We do need to revisit probably the second metric, but we have 2 metrics. The first one is, what's the average number of business days that the COGCC technical staff takes to make initial contact? So this isn't the complaint specialist. This is the technical staff now has it. It's been routed to them. They've looked at it. They have made initial contact with the complainant to let them know what they're planning and getting any other feedback before the investigation starts. We have a goal of 2 days. We're at 1.55 days. The second one is number of days to resolve the complaint from when we receive it to when we resolve it. Either we determined there were no violations, we determined there was, we determined there was issued an NOAV, we determined there was a spill, so now they're taking a Form 19. It's either resolved completely, meaning nothing's forwards, nothing new, nothing else is going to happen, or it's now following a different process, whether it's an NOAV process, whether it's a Form 19 for a spill, et cetera. That's what resolved is. We do have a goal of 60 days. We're at 14. So I think we need to revisit that 60-day goal. The reason we were with that is historically we had a lot of water well requests to test water wells, requests to spills. Those are ones that take a lot longer. Like a lighting issue, obviously we can resolve that pretty quickly, but a water well investigation takes a long time, and we're seeing that in the numbers. So that's where we're at right now. We're just under 14 days on average to resolve a lot of these, and that has a good mix of, you know, water well issues, spills, investigations, and then lights and noise. You'll see those in the next slide. So what are the top 15 complaints? I think one sticks out pretty clearly, and that's noise. So of the 270 issues, 90 of them are noise related. So hence the need to gather more technical data, as Director Lepore said earlier, on a noise rulemaking. Spills, I said we do have a lot of those, and those are the ones that do take a lot longer to investigate. There's a lot more that goes into it. Odor, lighting, access, and so on down. So breaking noise down, you have your A scale and your C scale. C scale is more the low frequency, some of the stuff that we're seeing more and more issues on. How many of these noise complaints had a C scale component to it? And we're about at 40% now. So who are they assigned to? So Jim Precup, he's the field inspection supervisor for the Northeast part. So that covers the DJ. No surprise here. He's getting a lot of the complaints. Jason Gomez works for him. So you can see his group. So I want to thank Jim. I want to thank his staff and Margaret Ash, the amount of time that they have spent on this. And a big reason this process, I think, has been a success is definitely that team, as the other teams also. We have a lot of royalty questions and just a lot of other issues. John Axelson's group, the environmental group in the Northeast, he's starting to get a lot more now. So I want to thank all these people. They've definitely been working hard to make this process a success. That's all I had for my update. I'm glad to take any questions. Commissioner Craig.
Particularly for Mr. Precup, it seems like his time is really being taken up with this. With this process in place now and functioning, how is the existing workload? Have you seen, I mean, is there a shift in what they're covering? Is more time being spent on this? Are there other things that have been sidelined? How is this fit into the normal daily business process?
So Mr. Precup has assigned 2 people to his group to investigate many of these complaints, or I think 3 people on his group to do most of these complaints. So his other people are still doing what they've done before. The process is more efficient, so that is helping quite a bit when the numbers are up a little bit, but they are obviously more efficient. But one thing Mr. Precup did tell me is he doesn't think there's a high increase in the number of complaints like that chart showed, just the number of complaints that went through a formal process. Previously, his staff would still get phone calls from people saying, hey, I know who you are, Mr. Gomez. I've got an issue. Can you come to my residence and check it out? And they would do it anyway. But we would never know about it in the office because there was never a formal complaint. So, I mean, they were still doing some of that. Now, is more time being dedicated to this where some of the regular work is dying, is going off a little bit? I don't know if Margaret, Ash, any thoughts on that? I mean, that you're seeing?
Yes, we can see a fairly significant decrease in the number of inspections related to complaint response.
I beg,
Later,
Margaret, I know you don't like to be in the limelight, but would you mind just coming up to the phone, the microphone? Grandmother Smith out in Delta wants to hear your response.
The complaints do take time. We're dedicated. It's the highest priority that we have and for the inspection group. And we have our guy, our quality assurance professional, Mike Leonard, who, since you he does some fairly detailed trend analysis and watching what's happening with inspection numbers. And we can correlate increases in complaints to decreases in inspections. Now,
there's something about that doesn't compute for me.
well, it takes a lot of time to do these complaints. You know, you go up to a nice multi-well site, one of these operators, everything's nice and shiny and new, and you can get a lot of really good quality well inspections in. But if you're going out in the middle of the night 2 or 3 times, taking noise surveys, you generally take them over an hour. You might take them at the residence. You might take them at the wherever the facility is. A lot of conversations back and forth. So the complaints actually do take more time. I mean, we do inspections. You know, if it's a facility, we do get an inspection count in there, but it's not as it takes more time.
Question.
In line with the normal business practice. In the normal business practice, there's like a triage situation where you are prioritizing those things that provide the greatest risk to the state, you know, to Colorado, to an area, whatever. With the complaint, that triage process may not, in fact, be functioning because it's a complaint, and that the risk associated with a complaint may not be as serious as the things that you're seeing. How are you triaging, so to speak, your workload? Because to me that there can be a disconnect there, an inconsistency.
Well, one of the things we've done over the last few years in the reorganization of the field inspection group is a lot of that work for complaints goes to the supervisors. So the other staff members are still able to go out and do, for the most part, their normal inspection routines. It's a pretty big burden on the supervisors, and we have a really dedicated group. But yeah, they take the complex issues and the time-consuming issues, and they're able to triage them. And while the other staff can, to the certain extent, continue with regular inspections and high-priority inspections.
Commissioner Benton.
Thank you. So this more is a question about the process, and have you heard more or less complaints about the complaint process? Is it going better or worse?
We haven't gotten a formal complaint about the complaint process. No, I haven't had from the public standpoint, I haven't had a whole lot. I will tell you, the very first person that filed a complaint, I actually called her up and told her she was the first one to follow the complaint process, and she was very complimentary about it. A couple other people have commented that they were favorable toward it, but we haven't really sought feedback out quite yet, except from that first person. So we haven't heard anything negative, which is good.
That's good.
Other questions? Thank you all very much. We appreciate the hard work on this.
Thank you, Commissioners.
Back to you, Director.
Mr. Chairman, I have nothing further. I'm happy to answer any additional questions.
A request that you tell me the dates of the special hearing set aside for task force recommendations, because I forgot to write it in my book.
November 16th and 17th.
Thank you.
And the regularly scheduled December hearing will be devoted to the rulemaking as well, to the extent that we haven't gotten it all worked out by then.
And the location of that, November 16, 17.
Denver. We don't know whether it will be in the Wasatch hearing room or a larger venue. It depends on the level of interest.
Okay, thank you. Any other questions for the director? Seeing none. And commissioner comments? You used up all of your ammunition previously. Okay, thank you. Now we have time set aside for audience comments. Ms. Murphy?
Chairman, we don't have anybody listed.
Well, even if you didn't sign up and you want to make a comment, we do have some time set aside for that, so. Okay, thank you. Now, just prior to going into our consent agenda, I think Ms. Murphy has some direction for us.
I do. As you all know, late Friday, one of the contested hearings scheduled for this morning was resolved, and so that item, docket 1507000434, has been added to your consent item package. As well, there's a correction in one of the enforcement items. It's 150900332. That matter ended up being resolved by an AOC, but we didn't correct the agenda. So in that docket number, we are asking you to approve the AOC entered into between staff and Carrizo. And I believe that you typically take the non-enforcement matters first, and then my understanding is that Mr. Allward or Commissioner Allward needs to recuse himself from one of those matters. So.
Okay, consent agenda. Did Commissioner Allward, did you have a request for recusal?
Thank you, Mr. Chair. So I'm going to recuse myself from an item in Group H, docket number 150400217. That's the WPX item. So I'd ask that that be considered separately.
Okay, I'm sorry, Commissioner, give me the docket number again.
So it's Group H and docket number 150400217, which is the WPX matter.
Okay, any others?
Mr. Chair?
Yes, sir.
Excluding that item I just mentioned, I move approval of groups A through T on the consent agenda.
Motion has been made and seconded. Just prior to voting on that, I had a question I just wanted to ask because I'm curious. Group J, Catamount Energy, docket 495. In looking at the interested parties in that group, none of them are local folks. They're totally California, Oklahoma, Texas. I was just kind of curious as to why we had so many. First off, can you give me a better idea of exactly where that is? I mean, I kind of know where Ignacio is, and I know where the Ignacio Blanco Field is. I know where La Plata County is. It's in the Hesperus area? No, oh, yeah, I do know. 9 times out of 10, I can find my way home. I was just curious about that. Your next item has lots of local folks.
Sure. Good morning, Commissioners. It is located. Tell us who you are. Oh, I'm sorry, Joe Pershala on behalf of Catamount Energy Partners. It's located along the southern Ute boundary, which a lot is near Native American lands, and there's allotment numbers that go with properties, and so a lot of those folks are just located out of state.
I see. Okay. It's not within the Southern Ute, the outer boundary of the Southern Ute tribe, but it's right next to it
Correct.
on allotments.
Correct.
Okay, that makes sense. I apologize. Thank you for your time. I appreciate that.
You're welcome.
Okay, we do have a motion and a second to approve the consent agenda items with the exception of the one that Commissioner Allward asked to set aside. All those in favor indicate by saying aye.
Aye.
Opposed, same sign. Consent agenda stands approved. Now, docket number 150400217 is up for grabs.
I will move for approval of that.
Motion to approve. And a second. Any discussion? All those in favor of approval indicate by saying aye.
Aye.
Opposed? Nay. Noted that Dr. Allward did not participate. That stands approved. Now then, we are going to move the Cub Creek matter up to the agenda. Oh, well, let me just ask Ms. Murphy to tell us what we're going to do.
I would request and suggest that we take up the enforcement consent items.
Oh, that's right. Thank you. Yes, ma'am. Enforcement Matters Group A.
So, Mr. Chairman, if I may,
Please, Commissioner.
I would move that we approve the enforcement matters in Group A as revised by Ms. Murphy.
Okay, we have a motion and a second. Any discussion? This includes the direction that Ms. Murphy gave us relative to requesting that we approve the staff's work. Okay. All right, motion and a second to approve the enforcement items. Any discussion? Hearing none, those in favor indicate by saying aye.
Aye.
Opposed, same sign, and those stand approved. Okay, Ms. Murphy, I'll let you tell us what we're going to do next so I don't make another error.
Chairman, you didn't make an error. You're just a little early. We are, I believe, prepared to take up the Cub Creek matter. I have seen counsel for both parties. Yes.
Do we need just a minute or two or three or five to set up? Okay, we might just take a very quick, let's just take a quick 10-minute break and then we'll reconvene.
There's one last spot.
Good. Yeah. Oh, okay, great. Nice to meet you. Yeah. That's good. Yeah.
Wow. Look at that. Okay.
So, and where is it?
You're going to introduce it first then. Okay.
Yeah, you're going to introduce your rice. Oh, can I put my bag right here? Oh my gosh. How's the price environment? Yeah. Yeah. Everybody's responding the same way. You want to keep business, you gotta cut prices a little bit.
Yes.
Yeah.
To go through the wrong way, wait about 6 to 9 months.
Yeah.
Yeah, why not?
I know, I keep waiting for it to come up, and then we were just talking a few minutes ago about Goldman Sachs making their prediction they were gonna drop to half of where we are now.
Oh, my God.
You know, nobody really knows, right? Exactly.
Yeah, they might.
Yeah.
elapsed and we're ready to reconvene.
Actually, there are a couple things.
Hey, Power, good to see you.
There is one.
Press or direction?
My direction would be to turn this over to the hearing officer, Jen Bach, and I think she can take us through this matter.
I didn't see her sneak up over there. Thank you.
Oh, I'm here. Thank you, Ms. Murphy. Good morning, commissioners. My name is Jennifer Bach. I'm the hearings officer on this matter. This matter comes before the commission on Cub Creek's application for an order to establish a 320-acre drilling and spacing unit in the north half of Section 12, Township 4 North, Range 68 West. A protest was filed by Kerr McGee. 2 pre-hearing conferences were held, but the parties were unable to reach a resolution. An application to pool all interests within the same unit was filed by Cub Creek for the October commission hearing. Kerr McGee then filed a motion to consolidate this matter, the spacing application, with the pooling application and continue it, but that motion was denied. After reviewing the file and testimony, staff recommends approval of Cub Creek's application. Each party has 45 minutes to present its case to you. Chairman, you have an order of presentation before you, as do the parties, and so I will introduce, guide us through that presentation.
Very well, and you have your watch with you, so I have trouble telling time.
Ms. Murphy will be
Ms. Murphy
the
will
time master.
time keep for us. Thank you.
So will the parties please introduce themselves?
Thank you. My name is Rob Willis. I'm an attorney at Shaner Collins Law Firm. I'm here with Cub Creek Energy, and seated at my table now is Scott Bailey, who's the Vice President of Land and Business Development.
Morning, Commissioners. My name is Mike Wozniak. I'm here with Jill Fulcher, and we're here on behalf of Kerr McGee Oil and Gas Onshore.
Okay.
So we'll begin with Cub Creek's opening statement.
I do have one preliminary matter. Mr. Wozniak and I did meet in the hallway, and we agreed to stipulate to the expertise of the witnesses that are going to be brought before you today. I plan on calling 3 witnesses, and I think Mr. Wozniak has plans to call several witnesses also. I'm wondering if I might expedite matters to maybe swear all those witnesses at the onset, and then we can just kind of get into presentations.
Certainly.
That's okay with me if it's okay with y'all and Mr. Marsh.
Sure. Would each of you raise your right hand?
Actually, if you're going to be a witness, would you go ahead and stand up so I could see your eyeballs? Thank you.
Do each of you swear under penalty of perjury that the testimony you will provide today is truthful and accurate? Thank you.
Thank you, Mr. Willis. Good idea.
Thank you, Chairman. I'll kick it off then, if that's all right. Good morning, Chairman, Commissioners. My name is Rob Willis. I represent Cub Creek Energy in this proceeding. Cub Creek is a registered operator with the Commission, whose principals have decades of experience in the oil and gas industry as both operator and non-operator. Last year, Cub Creek acquired interests in the northeast quarter of Section 12, Township 4 North, Range 68 West, 6 p.m. in Weld County, with the expectation of developing those interests to establish a rate of return on investment. These interests underlie the incorporated town of Johnstown, and presently have a residential subdivision developed on top of that. Following acquisition, Cub Creek successfully negotiated a surface use agreement with the landowner just outside of Johnstown for an oil and gas facility to be located in the northwest of Section 12. Following failed attempts to informally negotiate a development plan with Kerr McGee, the mineral owner of the northwest quarter, Cub Creek filed its amended application to establish an approximate 320-acre drilling and spacing unit for the north half of Section 12, with authority to drill 9 horizontal wells therein for production from the Codell Niobrara Formation. In a manner consistent with its opposition to Cub Creek's development plan, for the north half, Kerr-McGee filed its protest to the amended application. Cub Creek will present testimony in support of the amended application through 3 witnesses today. Scott Bailey, who I have introduced already, he's Vice President of Land and Business Development for Cub Creek. Dan Burbrick, he's Vice President of Exploration for Cub Creek. And also Andy Peterson, a consulting petroleum engineer. As you listen to the testimony and look at supporting exhibits, please consider the relevant provisions of the Oil and Gas Act, the COGCC rules, and Cub Creek's contemplated plan for development of this 320-acre planned unit area. Thank you.
Kerr-McGee.
Thank you, Mr. Chairman.
Time out.
Time out. Good morning, everyone. It's my pleasure to be here again to address you. It's always enjoyable, especially in such a beautiful part of the state, so thank you for having us. As I said, my name is Mike Wozniak. I'm here on behalf of Kerr-McGee Oil and Gas Onshore. And the first thing I want to tell you is, as you've probably seen, we don't protest many spacing applications. But my point to you today is this is not, in my view, a normal spacing application. We're going to have a lot of evidence today, and I appreciate Mr. Willis willing to stipulate to the expertise of all of our witnesses to save time. But as he mentioned, you know, Cub Creek was recently formed last year in 2014. And at least in my research, I could find no horizontal Codell or Niobrara wells that have been drilled or operated by Cub Creek. And this is sort of an interesting issue because sometime toward the end of 2014, a year ago, we understand that Cub Creek went out and acquired an oil and gas lease. And it's a partial oil and gas lease in the northeast quarter of the proposed spacing unit. Kerr-McGee has 100% of the northwest quarter of that same drilling and spacing unit leased. So we're the majority working interest owner in the proposed 320. Okay. Now, Cub Creek went out and bought this lease that they got that's in the city of Johnstown. And as we'll show today, it's covered by a very nice subdivision. It's got a beauty parlor. It's got some nice pastry shops on it. It's got churches. And so they were able to go out and get a lease underlying part of the city, which frankly, if we had gone out and gotten that lease, we would have known you can't really probably drill under it, okay? So they bought this lease recognizing they were going to have to figure out somebody else to drill on. So there's road uses, there's Johnstown all around them, but Kerr-McGee's 160 is not in the city. So what they're asking you to do is to take 9 wells, let's put them on Kerr-McGee, on our 100% leasehold. Let's not just go through the minerals underlying our lease, which oftentimes happens when you want to reach your own lease, but they're saying, no, we want to produce your minerals. Now, recognizing we haven't, as Cub Creek anyway, drilled any of these wells, we'd like to do that. We're also going to put a multi-well production facility on your surface. And at least from their APD, it looks like they've got 12 water tanks on our surface, 24 oil tanks, 12 emission control devices, 12 different separators, okay, and our roads that go right next to us into Johnstown. But moreover, from the surface impacts, we have serious problems with it. But let's talk a little bit about what they can drill from this location. First of all, they want to drill 9 wells from this location in the southwest of our land. And in order to do the angle that has to be drilled to hit the productive formation with a 460-foot setback means that the laterals, these 9 laterals, will be, from our point of view, short laterals. So when you're drilling a horizontal well, we'll have testimony today to show that it is much more economic and much more efficient to drill longer laterals. But because of this land situation, these are going to be short laterals, maybe 4,000 feet, maybe shorter. So based upon this, we're very concerned that what we have here in front of us is in essence sort of a science experiment. Let's drill short laterals. Let's put them on somebody else. Let's avoid dealing with the city because they're on our property. And we think it leaves significant stranded reserves. So for both waste issues and surface considerations, we think that this application ought to be not denied. And we all know that, and especially Mr. King knows very well, that in November, we're going to be talking about multi-well production facilities and where they ought to be located. Again, this one is located in a position that would be seriously challenged, I think, come December or thereafter by the city of Johnstown. I want to take you back to a couple of you, especially Commissioner Allward knows very well, and Commissioner Compton. In 2008, we were all together doing some new rules and regulations, right? And if you remember, a couple of those rules, for example, the geographic area plan rule in Rule 513, and more importantly, the comprehensive drilling plan into Rule 216, were things that we all sat around and said, shouldn't we do this on a more global basis? Well, you'll hear testimony today that Kerr-McGee began over a year ago working with Johnstown, developing a way to develop this area, okay? And part of this area to be developed, and their plan that they'll testify to today, deals with a very sophisticated water gathering system. Because we're all around roads. And as you well know, and we all go up to the county meetings, especially in Weld County, the first issue that I hear after noise is truck traffic. Okay, you'll hear today about Kerr-McGee's water gathering plan, which means all of the water produced from the wells in this area will be piped. No more trucks, no need to bother the residents like that. Number two, we have a gas gathering system that's being built about 2.5 miles south of this that can be extended, so no more flaring. Three, they're planning and contemplating an oil gathering system, so no more oil trucks. Now, they started working on this plan over a year ago with Johnstown, and as it moves closer, all of that infrastructure, at least in Kerr-McGee's view, needs to be put in before we run out and drill 9 wells, because 9 wells with the number of tanks I mentioned, 24 oil tanks, 12 water tanks. There'll be hundreds of trucks a day that have to get in and out of there through the city of Johnstown. So both from a prevention of waste point of view and how long laterals are more efficient and more economic, but we believe that our surface impacts will be significantly reduced on a global plan. Now, you know, Cub Creek can argue, oh, correlative rights, I may not get my wells drilled. Well, you'll see plans today to see that those wells will be drilled, whether they're operated by Kerr-McGee or whether they're operated by Cub is not the issue. The issue is, are we going to do this in the best way possible? Is this going to be an efficient development of the reserves? Are we going to prevent these stranded reserves with longer laterals? And can we do it economically? And remember, the third stool of your leg always, besides correlative rights and prevention of waste, is can you conduct your operations in a manner to protect public health, safety, and welfare? I would submit that Cub can drill vertical wells. They can drill directional wells if they have to hold a lease. But overall, let's try to do this right. And we've got a plan that we're going to show you today to say this whole area can be developed in a much more systematic way that will prevent truck traffic and that will allow you to balance those 3 things that you have to look at. So at the end of the testimony today, I'm going to ask you to deny this application. We don't need to rush forward. Let's develop this area the way it ought to be developed as a global operation similar to a comprehensive development plan. Thank you.
Mayor, question. Would you allow us to ask a question or two?
Of course.
Okay. Commissioner Ben.
Thank you, Mr. Wozniak. A number of times during your opening statement, you referred to or made a comment to our land, which implies to me that you own the surface. Do you in fact own the surface there?
No.
But you do have the minerals leased in the Northwest
We have the minerals
border.
leased, and I apologize for our land. This is Kerr-McGee's leasehold interest.
Thank you.
Thank you. I take ownership of things I shouldn't, you know.
Interestingly enough, that was my very question.
You know, every once in a while, I do have a spark in there somewhere and thinking something.
The other clarification, you have indicated, I think, I heard you say that Kerr-McGee does have a short-term, long-term plan in place where these minerals would be developed.
That's correct. That's what our witnesses will testify about today.
Okay, thank you very much. Any other questions?
If I could start then. I've got Scott Bailey. Scott, what's your name and what's your occupation?
Scott Bailey, petroleum landman by occupation. I've had various titles working for various companies, but my current title worked for Cub Creek Energy, and my title is Vice President of Land and Business Development.
Could you describe your experience working in the oil and gas industry, as well as working in the DJ Basin?
I graduated from University of Oklahoma with a petroleum land management degree and went to work for Amoco. I was with Amoco for 20 years, working various different offices, New Orleans, Houston, and Denver. I had 20 years of experience with Amoco. Left Amoco when they closed the Denver office and went to work shortly after that with Aspect Energy in Denver. 10 years with Aspect, and then after had an opportunity to work close with a couple of close friends of mine that have a lot of experience in business, and joined Tecton Energy, who drilled about 30, 40, 35 wells around the Windsor area, horizontal Codell and Niobrara wells as a management team. That project was sold about a year and a half ago now to another party, and we revamped the company and have now called it Cub Creek Energy. With the prices of the commodity going down, we have not been that active in drilling wells yet, but we are putting together locations and opportunities for us to pursue, and this being one of them.
Are you familiar with the COGCC rules and regulations as a result of your experience?
I am.
I've put on the overhead just a general depiction of this particular slide, which shows where these lands are actually located. I'd like to just go forward then to this next slide. Could you tell the commissioners what this slide demonstrates?
It's just a plat that depicts this section that we're dealing with here, which is section 12. The north half is colored in two different colors, showing the northwest quarter. The leasehold under that is owned by Kerr-McGee, and the northwest quarter, a majority of the leasehold under that quarter section is owned by the northeast quarter is owned by Cub Creek Energy.
Part of the application also indicates you're looking for a certain number of wells to be drilled. Could you describe what that plan looks like?
Yes, there are 9 horizontal wells that we plan to drill from a surface location that we obtained. Actually, we talked to the surface owner before we acquired our interest in this area, because it is under a subdivision, and we knew we were not going to be able to develop it from lands within the subdivision. There's no space to put a surface location to. So we tried to look for a location that was accommodable to the parties involved, and the mineral owner, which is also the surface owner in the northwest quarter, which is leased to Kerr-McGee, was very receptive to the idea, and actually was working with the party that we bought some of the leases from in the northeast quarter, and wanted wells to be drilled out here. So that seemed like a positive. The mineral owners really wanted us to proceed forward, so we obtained a mineral surface permit from the surface use agreement from Mr. Vail, the surface owner in the northwest quarter, and we've laid out 9 horizontal wells for the drilling in the north half of the section.
Now, there's also a setback which is requested under the application. Is that consistent with the development rules in the greater Wattenberg area?
It is a 460-foot setback for the boundaries of the wells.
Okay. Have you had a chance to survey either any kind of resource, whether it be COGIS at the COGCC, to ascertain what type of development pattern operators prefer in the vicinity of these lands?
For the horizontal wells, majority of the wells that we have seen have been 1-mile horizontals. There are longer laterals being drilled, but there's some efficiencies and inefficiencies of those, which will be testified to here later today.
Okay. When it comes to wellbore orientation and length, did you consider those factors as you plotted out your wells? For our purposes, we felt that this was the proper development for the minerals that we had, with co-developing for 1-mile laterals was the most efficient way to develop the minerals. Okay. Now, you've expended capital, obviously, in acquiring the lease, as well as the surface use agreement. And is it Cub Creek's practice to actually get a return on investment, or are you an entity that actually holds on lands and maybe trades them for par value or anything like that?
Now, when we bought the mineral rights, or actually the leasehold rights out in this quarter section, it was our intent to develop them in a timely manner. We know there's a permit process to go through, and title and other things that will not allow it to be done immediately, but within a timely manner. It was our intent, and we still would like to drill the wells in a timely manner.
So you've been I think you've already testified that you've been in contact with Mr. Vale, who is the surface and mineral interest owner underlying the northwest quarter. Have you secured, or are you aware of him actually submitting a letter to the commission which indicates his being favorable of Cub Creek operating wells on his land?
Yeah, he did submit a letter, and he is very anxious to see wells drilled as soon as possible.
What about any other royalty owners?
Two of the mineral owners in the northeast quarter have also submitted letters requesting, supporting Cub Creek's application to allow wells to be drilled in a timely manner.
Could I ask, Mr. Chairman, whether or not you've received those letters in your hearing packets?
You know, I
see
believe
a
they're in the
couple nods.
electronic packet, and I'm
do
trying to
have
find them as you speak, but I haven't come up real quickly with them. But they're in there, I'm pretty sure.
I do see some nods from your fellow commissioners, so certainly just like to draw your attention to those statements.
Electronic page 48, I understand.
Okay. Let's talk just a little bit about your history since you've owned these lands, Mr. Bailey. Have you attempted to reach out to Kerr-McGee to try to figure out how you can put this project together?
We contacted them numerous times regarding joint development opportunities for this acreage. Feedback we got is essentially they wanted to buy us out or make offers to trade out our interests out here instead of proposing a joint development plan that would be acceptable to both parties.
And have they ever come to you then and been able to actually describe what their plans are for these particular lands?
We have never been given any specific idea of the nature of their development plan for the area.
Now, in Mr. Wozniak's opening remarks, he talked about a comprehensive drilling plan, which is a possibility under the COGCC rules. Has anybody at Kerr-McGee ever reached out to you during the course of your owning these minerals and indicated to you that they were trying to put together this type of plan?
They have not.
Questions?
Commissioner Benton.
If I may, and I appreciate you putting that exhibit up. One of the issues that comes up specifically with looking at horizontal wells is that setback and that 460-foot setback, and ultimately how do you get at those minerals with horizontal wells in the future? And have you contemplated how you might be able to get that done, being that you're essentially honoring the setbacks per the rules and regs, but there may be some, you may not be able to drain all those minerals, and sort of what process would you go by in the end that this gets approved with, I can't remember who has the leases to the north or to the south, how you might be able to work that out.
The well pattern is laid out here is, I think, the ideal pattern. It is actually, the wells are approximately 460 feet from the setback. There's a little more distance than that, particularly in the north and south well, because as we drill the wells, we want to make sure we stay within the 460 setback, obviously. But keep in mind, there's nothing that would preclude overlapping units being formed at a later date through the 318A rule process. So with respect to the setbacks and the margins around there, other wells can be drilled that have overlapping units, and so that the wells don't have to be 460 feet away necessarily from the boundaries of our wells, or even 920 feet if you had two abutting units, right? So with the 318A rule process, you can form the overlapping units, and so the wells can be, the margins of the area can be adequately developed if it's not going to be drained by the current wells.
Because your interwell distance, implies that there's going to the possibility exists to drill some additional wells. is that pad that you have contemplated potentially set up to add some additional wells? Should that come about, is it makes the most common sense to drill those infill, those quote lease line wells from that pad site?
It could be. The pad has enough area that we could add some additional wells onto it. We don't have any restrictions that I can recall off the top of my head about the number of wells we can drill from that pad. The pad itself and then the northwest quarter, I don't think we have an arrow foot of the northwest quarter is completely, it's farmland, right? So
yes,
there's nothing around that area.
Yeah, there's homes on the northeast quarter.
Northeast
and
quarter,
also,
the northwest quarter, it's completely open.
The other section, the 320 immediately north has a bunch of houses.
It's more of Johnstown, but to the south and to the west of us, it's completely open. So minimal disturbance to the community of that location. And the thought process that there would be some boundary wells that would come into the 318A rule process to drill and develop the margins of the unit that we're forming for any hydrocarbons that might not be able to be drained otherwise.
And Mr. Wozniak alluded in his opening statement that I think there was a beauty parlor and some other businesses and so on in there, and there are homes to the north and also underneath, above where your minerals are located. Have you had any discussions with any of the residents there, any of the businesses about where you plan on building this location and drilling these wells? And if so, can you shed some light on what those conversations were
we
like?
have not had any specific discussions, although one of the developers of the area is one of the parties owns minerals, and they granted us a lease. So we have not had specific discussions other than have bought leases, mini leases from some of the lot owners. Some of the lot owners do own the minerals also. So they know we're actively out there. There are 2 wells actually very close to the center of the north half of the section. There are two directional wells that are currently producing. They're very close to a surface location, very close to a church out there. We could have looked at potentially using that location for our development. We just didn't think it was right for the community to do that.
Yeah.
We wanted to get farther away. But for the permit process, we will have open discussions with the community, and the city of Johnstown also will be involved in discussions for the permit process. But for the spacing, we just didn't think it was appropriate and necessary for the spacing, but for the permit process, we will have those discussions.
Thank you.
Other questions from commission?
I forgot to offer up Mr. Bailey for cross-examination. This might be a good time too. I'm not sure if Mr. Wozniak has any questions.
Thank you. I just have a couple of questions. I'll try to go quickly. Sorry about the speed, but we don't have much time, and I usually okay. And following up on the questions about the well path, are you able to keep your well path to reach the northernmost well on the exhibit that's up there inside the north half of inside your proposed drilling and spacing unit?
Honestly, I don't know the answer to that question.
Okay, but perhaps your engineer will. Have you just begun your USR discussions with Johnstown?
We have not.
Okay. And when you were with Tecton, you mentioned that you drilled other wells with Windsor. Isn't it generally a year, 2 years ahead of time that you start working with the adjacent municipalities?
When the well is located in the town, yes, I would agree. These lands where the surface is going to be are outside the town, and they will be notified in the permit process, and we will have a town meeting as they may request. But for this point, since we're not located in Windsor, we were inside the town, and so we did have the meetings much more in advance than we planned to here.
So did you consider any directional or vertical wells to hold your leases in the northeast quarter?
There actually are wells that are directional wells that are in there that are holding some of the acreage.
Oh, so your lease, I'm sorry, so your lease is held by production?
Some of it is held by production out there.
Well, some of it, so the whole northeast quarter?
That's not correct. It's the east-west half of the northeast quarter is held by production.
Okay, so
But
you're already...
the efficient way to drill the minerals and drain the minerals are through the horizontal wells that we've planned.
So you wouldn't drill a directional well to hold your leases then?
That would not make much sense when we can drill horizontal wells. They're much more efficient right now, because drilling another directional well, it seems like a waste of money.
You mentioned your well pad. It's about 4 acres, is it not, under your SUA?
I believe that's correct.
Okay, and you have nine wells, 24 oil tanks, 12 water tanks, 12 ECDs, 12 separators. You mentioned you had room to add additional wells in that. Have you really studied that to say you could add additional wells with all that equipment?
I don't design the surface facilities. The tankage that you said probably would be for potentially more wells. So well, engineer will be better apt to answer that question.
Okay. And you do plan to truck your water and truck your oil, do you not?
It may not be the case with the water. And in Windsor, we were fortunate we were able to work a deal with the parties that had water rights out there. So we actually brought water in from ditches. So water is the possibility of doing the same thing here.
So your disposal water, you're going to work a deal with the surface owner?
For frac water, I thought you were talking about.
No, what about produced water?
Produced water, we would be trucking that out in all
Okay,
likelihood.
and where's your water disposal facility?
We have not identified that yet at this point.
Okay, and oil, you're going to truck the oil, is that correct?
That would probably be the case.
All right, so assuming you drill all 9 of these wells, how many trucks will that be a day to truck that oil?
I'm not sure.
Okay, no further questions.
No redirect. I have a second witness I'd like to call, Dan Burbrick. Good morning, Mr. Burbrick. Would you please give your name to the commission and tell them what you do for a living?
My name is Dan Burbrick. I am the Vice President of Exploration for Cub Creek Energy.
Could you describe your experience in the DJ Basin from a geological perspective?
Yeah, I've been in the oil and gas industry since 1983, so 32 years. I've worked at DJ Basin on and off, a couple of stints, clear out into the eastern DJ, as well as this venture here the past year and a half with Cub Creek Energy.
Okay. Could you describe the depositional environments of the Codell and Niobrara formations?
Yeah, it's a marine environment from the Cretaceous Seaway, deep marine for the Niobrara, and then more shallow marine for the Codell.
And what type of characteristics do the rocks have which are underlying the lands?
It's an unconventional reservoir. We've got marl stones, chalks, limestones, shales, all very tight permeability.
Very tight permeability. Is that permeability enhanced by unconventional or non-conventional fracturing?
Absolutely, yeah. I mean, the horizontal technology and multi-stage fracking are critical to the economic development of these tight reservoirs.
So is it your experience based on the tightness of the rock that it's difficult to get a yield or recovery from these types of this type of reservoir? Should you not engage in multi-stage frac treatments?
It's absolutely the most efficient way to gather the resource. Historically, the vertical wells have produced, but right at the moment, the commercial quantities that are gathered by the horizontal wells are critical to the economics.
How thick is the Niobrara formation underlying these lands?
It's about 280 to 330 feet.
What about the Codell formation?
22 to 30 feet.
Okay. Which formation lies on top of which?
Niobrara is above the Codell.
And do you have an opinion as to whether or not these formations constitute a common source of supply?
They do. They're both continuous and present across the whole area.
And do you expect there to be commercial quantities of hydrocarbons produced from each well once they're successfully drilled and completed?
Yes, we do. Yeah, the recent low oil prices have reduced those rates of return, but everything's still commercial.
Okay. I have no further questions.
Cross?
Yeah. Thank you. Mr. Burbrick, I just have a couple questions for you. Do you have any seismic on the northwest quarter underlying Kerr-McGee's leasehold?
No, we currently do not. We attempted to acquire seismic early in the year and were denied the permit by Kerr-McGee.
Okay, and you testified that Codell is 22 to 30 foot thick in this area?
Yes.
Is that right?
Yeah.
And your contour intervals on your exhibit for the Codell are 50 feet thick, is that right?
That's correct, yes.
All right, so drilling without seismic with that level of sophistication is like steering blind, is it not?
There's a number of vertical wells here, and when you're drilling the horizontals, you have downhole tools that allow you to, detect the target and stay in the target. So seismic, although is very useful, is not critical to the project.
Okay, thank you very much. No further questions.
Thank you.
Any questions from the commissioners? If not, I have a third witness, Andy Peterson. Good morning. Would you please give your name to the panel and tell them what you do for a living?
Morning, Commissioners. I'm Andy Peterson. I'm currently Senior Vice President at Integrated Petroleum Technologies, which is a consulting company based in Golden, Colorado. Also President of Peterson Energy Operating, which is an oil and gas operating company based in Loveland, Colorado.
Do you have education and experience which is consistent with your line of employment?
I have a degree in petroleum engineering from the Colorado School of Mines. I'm a registered professional engineer in Colorado. I've lived and worked in the DJ for over 30 years. I've been a consulting petroleum engineer in the DJ for over 25 years. And I've been an oil and gas operator in the state for over 20 years.
You ever testified as an expert in your field, which is petroleum engineering, before any oil and gas commission?
I have. I've been admitted as an expert before this body, before the Wyoming Oil and Gas Commission, and the Nebraska Oil and Gas Commission.
Okay. I'd like to just move forward then. Are you familiar with the application lands?
Yes, sir.
And have you reviewed Cub Creek's land position as well as the geologic characteristics for the application lands?
Yes, I have.
So you're aware, based on your review and talking to the geologist in this particular case, that the Niobrara and the Codell Formation underlies the acreage, right? And that it's a common source of supply.
In my opinion, both of those are correct, yes.
What I'd like you to do is have you talk about exhibit number 7, which I've thrown up on the screen right now. What does this exhibit show?
Exhibit 7 shows the north half of section 12 towards the bottom of the exhibit, with some recently permitted and drilled and completed horizontal wells in the neighborhood, showing both north-south orientations and both 1 mile and 1.5 mile laterals. I don't believe there are any 2 miles shown on exhibit 7, but exhibit 7 demonstrates that both short laterals, if you're calling a 1 mile lateral a short lateral, and medium laterals, the 1.5 mile version, are both common in this area.
Now the yellowed area, what does that boundary call out?
That's the town of Johnstown.
All right. And so if you look above that, let's say in the next section, a group of sections above that, I see some well bores that appear to be in purple, maybe some in green, maybe some in blue. Could you maybe kind of tell the commissioners what that noise looks like, what that means?
Those are depicting various phases of the operation. Some are permitted, some are drilled, some are being drilled, some are completed. Some have the completion information turned in, some don't. So they depict various phases of the permitting, drilling, and completing operation.
Now, I've got a pointer here, Mr. Peterson. I hate to surprise you with the use of that, but there's a button on the top, that red button, and you can see it. I think most of the commissioners are looking at this screen behind us.
Okay.
And so I'm wondering if you could look at, it looks to me like that's a continuous well bore that maybe starts in the left side of the screen and goes to the right, but that's not the case,
And
right?
that's not actually the case. There's a pad right here where well bores go this way to the west and this way to the east. Same with a pad right here, I believe, where you got some 1.5 miles going west and some 1.5 wells going east. These are 1 miles, these are 1 miles, these are 1 miles, these I believe are 1 mile.
Excuse me, how about talking into the microphone? It's a little hard.
Excuse me. Would you like me to? So.
You know what I'd like you to maybe even point out is, it looks to me, and this being continuous, if you look down at where our application lands are, you can see the 460-foot setback there, right?
Correct, right there.
And you don't see
And
that
there,
above.
and
Who's
there,
the
and
operator
there.
for those charted wells above? Do you know?
Specifically where?
The ones way above that we were talking about.
Extraction has some of those. I believe Synergy would be up there, and possibly Anadarko.
And so that 460-foot setback that Mr. Wozniak was talking about in his opening, you don't see that above in that configuration of those wells. Is that because there's a different technique involved, or?
Those wells appear to have boundary wells permitted on the northern and southern borders.
All right, thanks. I'm going to move forward to this, Exhibit 8. And what is this exhibit?
Exhibit 8 is a composite decline curve prepared by IPT, averaging and combining approximately a dozen nearby horizontal wells to come up with a composite average production type curve for a Codell Niobrara well that Cub Creek might expect to realize by drilling on this acreage.
And is this calculation useful to you as an engineer? And if so, can you describe how?
The decline curve analysis, we're able to estimate the ultimate recovery from an average horizontal well and use that to compare to the estimated oil in place and run reserve calculations and economic calculations.
Okay. Let's move forward then to Exhibit 9. What I'd like to do is maybe take this apart a little bit. I know that it's hard to see, at least on what I'm looking at here. There's a better version on this screen, and I think it's in the commissioner packets too, as an exhibit. Could you tell the commissioners what this is?
Starting from the top, the porosity is the amount of holes between the sand grains or the shale particles, and that's measured off of well logs, specifically from the 2 logs that are in Section 12, in the north half of Section 12. Water saturation is an estimated number. That number can vary. I've seen as low as 15%, as high as 55%. 34% is a number that's been used in previous testimony in this area. 320 acres, the proposed drilling spacing unit, 120 feet net pay, and that's calculated from the footage in the Niobrara Formation that's greater than 20 ohms of resistivity, and in the Codell Formation greater than 10% porosity. And one can discuss or argue net pay thicknesses in the Codell Niobrara, but 120 feet of net pay is a good average number. The formation volume factors are used to convert the estimated ultimate recoveries into downhole volumes. And then the box below it, the calculated oil in place. I have estimated the hydrocarbon pore space or the hydrocarbon reservoir volume by using the factors in the top box, coming up with 20 million reservoir barrels of hydrocarbon reservoir volume and 66,000 barrels per acre, 41 million per square mile. The box below that takes the estimated ultimate recovery of the 2 vertical wells in the section, which is not that much, but in figuring the overall recovery factor, we need to know what the verticals have produced. And then the box below that is coming off the composite decline curve that we showed earlier. We're estimating the oil and gas in the estimated ultimate recovery surface barrels there. The third line down in that box does contain a mistake. The 230.7 MSCF should actually be MBOE. So that's 230,000 MBOE, not 230 million standard cubic feet.
What's that mean, MVOE?
Thousands of barrels of oil equivalent.
Thanks. Okay, go ahead.
So the recovery factor, and I'll get into that a little later, the recovery factor, when we take the surface volumes that are produced and put them down in the reservoir via the formation volume factors, we estimate that one horizontal well should recover approximately 3.5% of the hydrocarbons in the 320 acres. The box below that takes the 9 horizontals, and we come up with a combined 1 million barrels of surface barrels and 6 BCF or MMSCF of surface gas. We combine that with the 2 existing vertical/directional wells, put all that together, put that back into downhole volumes, and we come up with an estimated 32% recovery factor if all 9 horizontals get drilled and the 2 verticals get produced to abandonment. Approximately 1/3 of the hydrocarbons in that 320 should be recovered.
Does that give you any idea as to what each horizontal well will drain approximately during its life?
Based on those numbers, 1 horizontal well should drain approximately 11 acres.
Okay. Do you have an opinion as to whether or not the number of wells which are called for in the application before the commission now is smaller than what they can drain?
In my experience, based on my calculations, the estimated ultimate recovery from the 9 horizontals is such that the 320 acre proposed drilling spacing unit is not smaller than, in other words, greater than the amount that these wells will drain.
Now, in your calculations, you talked about the existing directionals, those 2 wells. Those wells are conventional completions, is that right?
That's correct. Currently Codell only.
And you indicated that the recovery from those wells is about 3.5%, is that right?
It's actually less than 1/2 of 1%. The 3.5 is for the horizontal wells.
Thanks. Thank you. I'm sorry. So could you go back again, just for my purposes, and let me know what the recovery factor is from those existing wells?
From the existing wells, they're going to recover less than 1% of the hydrocarbons in the proposed drilling spacing unit.
All right. Thank you. And obviously, you'll see a great enhancement then as you work in these non-conventional or unconventional wells through completion and production.
Hopefully.
All right. Have you had an opportunity to look at economics for this project?
I have reviewed some economics prepared for this project, yes, sir.
And what do those economics indicate to you? Is it a positive or negative venture?
The economics indicate that an average horizontal well can be drilled in this acreage, an average 1 mile horizontal well can be drilled in this acreage at a positive rate of return.
Do you have an opinion as a petroleum engineer as to whether this application, if approved, would prevent waste?
In my opinion, it would prevent waste.
And let's talk about correlative rights then, and your understanding of correlative rights. Are they protected by the granting of this application?
I believe so.
And how do you make that representation?
In my opinion, by combining the 2 160s, owners in both 160s share approximately equally in the production from a horizontal well, and therefore the owners in each 160 are protected. And outside the acreage, the offsetting owners are protected by virtue of the fact that the currently proposed wells will be drilled greater than the 460-foot setback from the lease lines.
There's been some discussion or comment regarding Cub Creek's ability to actually drill and complete wells. Based on your experience as a petroleum engineer and your assessment of the situation, or maybe your involvement with Cub Creek, do you have an opinion in that regard?
IPT has helped Tecton Energy, who are the managers of Cub Creek, were former Tecton Energy Manager. IPT's been involved with Tecton since approximately 2011, helping them drill verticals and directional wells. And Tecton drilled, I believe, 31 horizontal wells plus 9 directionals, 40 total wells in Weld County, Colorado. I was involved with all of them. And Anadarko had a working interest in nearly all of those wells, ranging from 5% to 50%. So Anadarko received the reports and paid their share of the bills and knew what Tecton was doing. And toward the end of the Tecton drilling program, we were invited down to Anadarko's Denver office to have a meet and greet and share some of our drilling technologies and completion technologies with Anadarko because they had seen the results of the wells and the costs of the wells. And we had a nice discussion and went over how each of us did our wells. So in my experience and opinion, the Cub Creek management is extremely familiar with drilling and completing horizontal wells in the DJ.
Thank you. Once again, I'm looking at Exhibit 9. I haven't moved introduction of these exhibits into the record. These are demonstrative exhibits. What I'd like to do is ask whether I can move Exhibit 9 into the record. I think that's very substantive. I think it kind of demonstrates his work product, and I'd like you to receive it for evidentiary purposes.
No objection.
So done.
And I have no further questions for Mr. Peterson.
I do.
Cross.
First or?
Go
You
ahead.
first.
Okay.
Be my guest.
Mr. Peterson, just a couple questions. The same question I asked Mr. Bailey. Will your well path laterals be able to be drilled entirely within the north half, or are you going to have to go to the west to be able to reach the locations that you've platted?
In my opinion, the Cub Creek wells, Cub Creek laterals can stay entirely within Section 12 and be successfully drilled.
Really? Interesting. So what would be the lateral length of the northernmost well then, if you stayed solely within the north half?
Approximately 4,000 feet.
And that would be productive zone?
That would be the productive zone. We could cut approximately 4,400 feet, and if we stayed entirely in the northwest quarter, that would cut a couple hundred feet off.
Okay, so when you describe 1 mile laterals, you're talking about that 4,000 foot lateral you just described?
1 mile could be up to 4,360, and if we had to cut the lateral off due to drilling constraints, it could be 4,000 feet, correct.
Okay. Do you generally believe that it's more efficient to develop an area on a global basis or on an individual 160?
Developing wells, I should say I've made no study regarding global development plans. I have been involved with the drilling of at least one 160-acre horizontal well, and in my opinion, the economics of drilling that are marginal.
Okay.
Were marginal, excuse me.
When you selected this 320, did you look to the north, the east, or the south for the other 160, or did you just decide to drill that on Kerr-McGee's minerals?
I would have to defer that to Cub Creek because I did not select anything here.
All right, so from an engineering point of view, you didn't look at any of the other alternatives?
Not yet, no, sir.
Okay. You mentioned that if this well plan did not adequately drain, that you would propose drilling 318A overlapping wells. Is that a correct statement?
Again, I would say that Cub Creek would have the opportunity and the ability and the option to propose 318A boundary wells, and I would defer to them.
Okay, well, you do understand Rule 318A allows anyone that receives a proposal that happens to be an owner to object to that on the basis that the proponent does not own that leasehold. Do you not?
Correct.
Okay, so that the trespass can be objected to under those circumstances.
I'm here to testify on engineering matters, and I'd prefer not to get into the regulatory details, sir.
Okay, no further questions.
I have one.
We have a question from Commissioner Benton.
So, Mr. Peterson, just to help me out a little bit in that exhibit that was just entered, I think Exhibit 9, I believe it was, which was the table and showed the 32% recovery factor at the bottom. You express your EUR at the bottom as 6.7 million reservoir barrels. What would that be if you express that in barrels oil equivalent, similar to the table up above, which said 9-well EUR would be 1.1 million stock tank barrels and approximately 1 million BOEs equivalent on the gas basis. So around 2 million barrels equivalent on a surface basis. So I'm just struggling with the conversion from the 6.7 back to the 2.1.
So if we take the 230 MBOEs times the 9 wells, we'd get a couple million surface BOEs.
Yes. So how do you get that? So I'm so used to seeing this expressed in surface barrels where you said you're using reservoir barrels down there at the bottom of EUR. How do you back from that 6.7 back to the 2 point?
It would work out the same if we took the reservoir volume and converted that to surface conditions and compared the surface EURs. I'm just taking the surface EURs and putting them back into reservoir volumes,
So-
but the ultimate result should be the same.
So what you're saying is approximately on a surface barrel basis, it would be that 6.7 would be 2.1 million barrels plus or minus on a barrel equivalent basis, surface barrels.
Believe so.
That's about the same. Wait a minute, I'm confused. If the formation volume factor is 1.07, for all practical purposes, it's 1. How are we
No,
going?
the gas is a big component, so the gas occupies about 0.5% of the volume in the reservoir that it does at the surface. And the MBOE, the MBOE is a conversion based on BTUs. So those aren't really
All right.
apples and apples. I shouldn't even have included the MBOE line. It's a convenient number. It's a good rule of thumb, but it does confuse things as far as where we're taking stuff and putting stuff.
Yeah,
It's a BTU conversion and the others are volume conversions. They're
Right.
different.
I mean, for the most part, we're used to looking at things expressed in surface barrels and recovery factor expressed in surface barrels rather than
Okay.
reservoir barrels.
And that could be calculated.
So,
But you understand what I'm saying about taking the surface and putting them in the reservoir.
I vaguely remember that, yeah.
Okay.
Petroleum engineer. So would it be fair to say, I mean, there's some, let me go back to, there's another exhibit that's very similar to this. Let me see if I can find that. I'm going the wrong way. This would be in Commissioner's Exhibits, page 115. Is it? I don't remember what the proper terminology is at. It's in our Part B, page 74 of 89. It's a similar exhibit that you submitted with your, I believe it's the, was it the 511 testimony, I think you mentioned?
Yes.
Yeah, and it shows recovery factors are around 6.6% for oil and 6.4% for gas. So if you could kind of help me out with the comparison between those two.
Excuse me, you were referring to a different recovery factor?
Yes, sir, that's right. It's on a different amended,
Right.
a different exhibit. And it looked to me like that was expressed in surface barrels and surface gas volume. So I wasn't sure if you could help me out understand.
Those calculations were done early on by staff at IPT. When I reviewed those in detail for this meeting, I changed a number of things. You'll notice, or you may not have the backup calculations, but The water saturation is different, the net pay is different, and the formation volume factors are somewhat different too. So I had some questions on the methodology that went into the original numbers, and in being prepared to sit here and defend what I'm telling you, I redid the numbers.
Yeah, I noticed this is missing a gas formation volume factor also.
Correct, and that was actually used with a B sub G, in which the attempt was made to take the total hydrocarbon volume and not deal with it in the discrete phases, but take the total produced volume and deal with one volume factor. And I frankly think this way is, it was easier for me to understand. One other factor being, in the reservoir, we don't really know what's oil and what's gas. We know what the hydrocarbon volume is. So if I can take what I believe to be the surface volumes, I know based on the decline curve analysis, I know how many barrels of oil and how many MCFs of gas should be produced. Those I can easily convert with readily available correlations back into reservoir volumes. And it was easier for me to understand. I hoped it would be easier for you to understand. I apologize if it's not.
Thank you. I won't take that as disparaging my lack of engineering knowledge.
I did not intend to.
Thank you.
If there are no further questions, I'll close my case.
Okay. We've turned to Kerr McGee.
Mr. Chairman, I have a motion, but it would take me 2 minutes, but I don't want it to count against my time. So if you'll tell me that I can take 2 minutes, I'll make it. If you tell me it counts against my time, I'll just wait till the end. So I need you to tell me that, because we only have I don't know how much time left, and we've got a whole case to present.
I have 29 minutes and 23 seconds.
I won't make it. Never mind.
Good job, Julie.
I'm supposed to switch.
Does the minute he just took count?
Ooh.
Can you give us a minute not on time while we set up? Thank you.
We'll hear it later.
All right. Good morning, Commissioners. Again, my name is Jill Fulcher, representing Kerr McGee. With me, I have Mr. Nelson. Mr. Nelson, please state your name and briefly your position with Kerr McGee.
Good morning. My name is Enrique Nelson. I am the Wattenberg Land Manager for Anadarko.
Thank you. Going on to Exhibit A here. Please describe this exhibit for the Commissioners.
This exhibit describes Section 12 of Township 4 North, Range 68 West. The proposed 300-acre spacing unit by Cub Creek. The northwest quarter depicts Kerr McGee's 100% leasehold position, and the northeast quarter in which Cub Creek purports to have a majority leasehold interest in.
Thank you. Moving to Exhibit B. Please describe this exhibit for the Commissioners.
So Exhibit B is a little zoomed out depiction of the general area. Section 12 is shown with the dotted line that depicts the proposed spacing unit and horizontal wells. The blue acreage represents Kerr McGee's leasehold and/or mineral interests within the area.
And has Kerr McGee strategically acquired that leasehold in this area?
We have.
What is Kerr McGee's overall purpose in acquiring contiguous acreage as we see here?
We can invest significant capital to consolidate our lease position so that when we develop our plans for the area, we can prevent waste in the subsurface as well as on the surface. We build out our infrastructure prior to going into an area and drilling our wells. We work with municipalities. We try and limit our disturbance on the surface by virtue of bringing in that infrastructure, which we have plans to do for this specific area.
Thank you. So we'll move to Exhibit C here. Please describe this exhibit for the commissioners, Mr. Nelson.
So this is an aerial image of the area. It shows Section 12 and the proposed 300-acre spacing unit. In the northeast quarter is some housing developments, as well as to the north. Johnstown Reservoir is located there, as well as a church and some other businesses. And the crosshatch represents Anadarko's leasehold and/or mineral interest position.
And just for purposes of clarification, can you identify Cub Creek's proposed drilling location on Exhibit C?
It's in the southwest of the northwest, located on Anadarko's 100% leasehold.
And you heard Mr. Bailey testify that Cub Creek has a surface use agreement with the surface owner. Are you familiar with that document?
It's been presented, yes.
And just briefly, does Kerr-McGee have any concerns over the validity of that SUA?
We do. As the leasehold owner, we were not consulted with as to where that surface location would have been placed. We have concerns in that by virtue of Cub Creek's plans, there's stranded reserves, which would potentially call for Anadarko to place an additional surface location on this northwest corridor to capture those stranded reserves.
Excuse me, if I could pose an objection to that and maybe request it be stricken. I don't think we're here to talk about the SUA and what the SUA purports to say. It's not within the commission's jurisdiction to interpret contracts or agreements between parties. So I just request that that response be stricken. It's not relevant.
Respectfully, we would ask that that response stand in the record. Mr. Bailey actually brought the SUA into evidence whenever he testified to that previously on direct. So because it was part of direct, it's perfectly acceptable for Mr. Nelson to be addressing the validity of that SUA.
Makes sense to me.
Thank you.
We'll keep
Thank
it
you.
in, yes.
Moving to Exhibit D, Mr. Nelson, please just briefly describe Exhibit D for the commissioners.
This is also an aerial image that shows a more current depiction of what the surface looks like today. As you can see, there's been more surface development, housing development there in the northeast quarter, in which Cub Creek has leasehold interest. The blue outline represents the municipal boundary of the city of Johnstown. So down in the southwest part of this aerial image is outside of the municipal boundary, which includes the northwest quarter, which Kerr-McGee has 100% leasehold in.
And does Kerr-McGee intend to develop its minerals in this area?
We do.
And where is Kerr-McGee in the process of developing its minerals?
We have started contemplating a holistic approach to developing this area. We are actually later this year in 2015 going to be drilling a number of horizontal wells 2.5 miles to the south of this location, which we have invested significant amounts of capital to bring in oil, gas, and water pipeline infrastructure to the area.
And approximately how far in advance of filing an APD does Kerr-McGee begin working with municipalities and developing and building its infrastructure?
Well, in excess of a year is generally the time frame in which we approach the municipalities. We've actually been working with the city of Johnstown for approximately 2 years. We've drilled some wells within the municipal boundary. Even though that this northwest corridor sits outside of the boundary, we would certainly engage the town and the communities prior to going ahead and developing that leasehold.
Based on the surface uses we see here in this aerial photo, in your opinion, could Cub Creek's development within this area cause potential adverse impacts to surface?
We see it as potentially impacting the surfaces negatively because of the setbacks that they need to abide by in stranding those reserves along the western and eastern section lines. And so we see that we would potentially need to add an additional surface location in the northwest corridor as well. And their plan calls for a significant number of trucks to truck their oil and produced water.
Would these type of impacts be avoided by more of an integrated field planning approach?
They would.
Thank you. And just for the record, were exhibits A through D created under your direction and control?
They were.
And are exhibits A through D true and accurate?
Yes.
So at this time, we would move to admit exhibits A through D into the record.
No objection.
And we are, this concludes our directive, Mr. Nelson, so I'd open it to
Can I
cross.
ask a question?
You
Go
may,
back.
Commissioner.
Thank you. Go back to your leasehold map.
Nope.
Now, I see an awful lot of white spots in that leasehold map, and some of them are in between. At what point were you going to engage the people who have the white spots in your program? Because we're here today mediating an issue because somebody that has a white spot hasn't been contacted by you all about the development plan. That's what this is coming down to. So we're facing this situation because our rules indicate that if there's a leasehold interest, somebody has the right to come and ask us to approve a plan for drilling. At what point you're engaging the city, that's fine and that's great. But there are other people that own mineral rights within the blue area. When were you going to engage them? How soon? Because right now we're here today because you didn't engage one group soon enough.
We have met with Cub Creek, is who I believe you're suggesting the party to be. And our development plan did not meet their timeline. And so that is why we were not able to further our co-development plan with them.
Could I ask for a clarification? Because I thought Cub Creek testified to the effect that Kerr-McGee had not talked to him about the development plan, had only contacted him about buying them out.
No, well, we met with them. I met with them personally. And if our timeline did not work within or meet their next 12 months is what they suggested, then they didn't want to discuss that.
I see you looking at me, Commissioner Benton. Can I help you or?
Well, I don't know who to ask that question because I was, right, it doesn't count, this doesn't count for Mr. Wozniak's
I understand
time.
that, but if you're looking for an answer to a question from me or my side of the table, you know.
Well, I am confused because I thought that I heard, and I've made a note to the effect that Mr. Bailey testified that there had been some meetings with Kerr-McGee, and also I believe Mr. Peterson testified that there were some technical meetings, but with respect to developing this area, that there was not a presentation to Cub Creek of Kerr-McGee's master development plan. And I apologize if I happen to say Anadarko occasionally because it really is Anadarko.
Well, you know, I could certainly put that on a redirect question, but Mr. Bailey's here, and since the question's topical, I'd certainly allow him to entertain a response to that, if that was right with Kerr-McGee.
Somebody has to help me out, and I don't know what the,
Yeah, I think
I'm
if
not the
it's-
right person to
It's
answer.
timely, Commissioner has a question, he can get that answered, it's on commission time, nobody gets any time taken away. That's my judgment, but you guys know. Please, go ahead, ask it, you answer it.
Okay. Would you please provide a little more clarification for me on the discussions that you had with Kerr-McGee / Anadarko with respect to developing this area?
We had a meeting with Kerr-McGee, and we were prepared to listen to the development plans they were going to set up for this area. That's what we anticipated that would come out of the meeting, that we could negotiate a mutually agreeable development plan. And they did not present any development plan for this area to us. They said that was our development plan was not consistent with theirs, and that's all they would tell us at the time. And we did express an urgency and a desire to drill in a timely manner, but Kerr-McGee never did set out their development plan at all.
So it might be safe to say that in line of that you have a 12-month timing. It's possible they may have said sharing that development plan might not be of much value to them because your time frame is different.
It seemed like it would still be beneficial.
Speculation on my part.
It's still been beneficial for us to know what their development plan is so that we could at least understand if it was going to be something that we could maybe mutually agree upon and work around.
Fair enough.
We even offered to have expressed interest and willingness to allow Kerr-McGee to operate the wells even for our plan. We just want to see wells timely drilled out here. But without a known alternative development plan, we're really at a loss for what to do other than proceed through with the hearing that we're in today.
Commissioner King.
So I'm coming back over here. What is your development plan for this parcel that you hold the entire leasehold to?
Yeah, Commissioner King, it may be best to save that question for our technical witness. Mr. Nelson can speak to it generally as well, but.
Yeah, we're currently working on that, sir. It didn't, in our conversations with Cup Creek, they were very specific that if we weren't going to meet their 12-month window, that they were going to move forward then. And we were very clear that we were not going to meet that window. And so I think Commissioner Benton's assumption is exactly correct in that putting forward those development plans were somewhat of a moot point during that discussion.
So, but when you do move forward, is there any scenario under which you wouldn't be back here with the pooling and spacing order to include Cup Creek?
It's possible. It's possible that we would develop our leasehold in section 11, 1.5 mile laterals to include just our northwest quarter.
Show me 11. Use the.
What's that, sir?
Can you show me up here where section 11 is?
It's the section just to the west.
To the west.
Got
there.
it.
Yep.
You can just see 11.
Right there.
Well, now that you've brought that up,
and go ahead.
If you did that with 1.5 mile wells, then would you not be stranding Cub Creek's minerals? Because then they're stuck with doing a 160.
It's very possible we would include their minerals to develop as well.
Or not.
Or not.
Okay, any other questions? It appears the mineral interests have some concerns about timely development, which may be a reason why they wanted to work with Cup Creek. Yeah, that's just a comment. Okay, any questions? So I think then we're back to Kerr-McGee.
And thank you, Chairman. I think that Cup Creek actually has cross-examination.
It's my cross-examination.
Oh, my goodness, thank you.
But I got to tell you, after I've now considered the statements, I don't have any other questions for Mr. Nelson, so I'll pass.
Okay.
Well, then, just one additional question at this time for Mr. Nelson. We've heard that there's some.
Excuse me.
I'm sorry. Oh, excuse me. I'm sorry.
Well, I don't want to get caught up in a technical objection here. I'm not sure what the question is.
No, that's fine. We don't have any further questions of Mr. Nelson either. My apologies. I got a cart before the horse.
So they don't get a redirect? Oh, there was no cross, so we don't. Okay. Yeah. I'm sorry.
I know. I was right there with you.
Gotcha. Okay.
All right. Thank you, Mr. Nelson. And at this time, we'll have Mr. Trigestad.
Thank you.
Come forward. Mr. Trigestad, please state your name and your position with Kerr-McGee.
I'm Mike Trigestad. Thank you for having me here today, Commissioners. I am the Development Planning Manager for Anadarko for the Wattenberg asset. I manage a team of engineers and geologists who evaluate our acreage position and then help coordinate the well planning all the way through to the drilling operations of our development here in Wattenberg.
Thank you. Moving to Exhibit E, please briefly describe Kerr-McGee's horizontal well development experience to date in the Wattenberg.
Yeah. So in our core operating area, which includes the application area that's in question, we are either fee or leasehold owners on over 350,000 net acres, mineral acres, in the DJ Basin. We've drilled over 1,000 horizontal wells to date, majority of those being within the last 3 years. And in 2014, 2015, we'll drill north of 350 wells per year. And in 2016, we're contemplating an additional 300 plus for that year. So we are a very experienced operator in the basin.
And does this experience include horizontal well development near the disputed acreage?
It does.
Thank you. Moving to Exhibit F, please describe this exhibit for the commissioners.
So having a dominant acreage position in our core area allows us to engage in what we call integrated field planning. And there are many advantages to being able to plan in an integrated way. On the left is a depiction of what happens when you have multiple operators that are not cooperating with one another and not drilling wells all the way up to the lease lines and pulling each other in, or drilling wells in alternative directions. You'll see that there's a fair amount of stranded reserves denoted by the yellow boxes. You'll notice that there are more pad locations that are not centrally located or coordinated. And you'll notice that there's a propensity for short laterals or less than 1 mile in length. On the right is if you take a more holistic view and plan the wells with longer wells with fewer surface locations. We believe this is a much more efficient way to operate. We do this as our norm now in the basin, where we do pool in other mineral owners as we go. We do not intend to strand anybody when we lay out our wells. It allows us to concentrate our surface areas, bring things like pipelines and water on demand and tankless facilities into the equation. And then we also engage local governments early on in this process, as we have in some of our ongoing developments, for example, in Fort Lupton, the town of Erie, Carbon Valley area right now.
Has Kerr-McGee drilled short horizontal laterals in the Wattenberg?
Absolutely. We've drilled a high number of those. In the past, it was by necessity, as we had kind of a checkerboard acreage position. Post the trade with Noble, we've got a much more contiguous position that allows us to drill longer horizontals, which we think are more efficient and also reduce the surface impact and allow us to get access to minerals where people live without impacting their lives.
So where Kerr-McGee has the ability to drill longer laterals, would Kerr-McGee ever choose to drill a short?
Our preference is for, we think the most beneficial is 1.5 mile laterals. In some places, 2 mile laterals will perform even better than a 1 mile. But our general preference is for longer laterals.
So do you have experience with development without integrated field planning, as we see to the left side of Exhibit F?
We do early in the development of the field for us, and you ended up with situations more similar to the left.
And based on Kerr-McGee's leasehold position in this area, does Kerr-McGee have the ability to drill with integrated field planning, as we see on the right?
Yes, and that would include Cup Creek's acreage as well.
And does Kerr-McGee intend to develop the subject lands and the adjacent lands in this manner?
Yes.
And has Kerr-McGee started the integrated field development process for this area?
We have.
All right, let's move to Exhibit G. Please describe this exhibit for the commissioners.
This exhibit just shows that even with short horizontals, you can not strand acreage along section lines. With the heels of horizontals either approaching or in some cases crossing the section line, you can reduce the number of surface locations required and have a more efficient operation.
Thank you. Moving to Exhibit H, briefly describe this exhibit for the commissioners.
This is an image from part of our ongoing integrated field planning. This is a part of the field that we call Uncompahgre. It's just northwest of the town of Hudson. The point of showing this is the box on the top shows what happens when we have wells that are not operated by us or our partners, drilled perhaps in the wrong orientation and causing us to strand some acreage. Whereas the center of the image, depicted by the box on the bottom, shows how we are using long and medium length laterals to more efficiently access all of the minerals within that area.
Moving to Exhibit I, please describe this exhibit for the commissioners.
So this is on the left is a map view, and on the right is a cross-sectional view of an operation similar to the one that Cub Creek is proposing. The green areas are stranded reserves, and the orange area on the cross-section is the target zone. So you can see the well, it has a back build that stays within the section and lands 460 feet or further away from the section line, and drills until the point where it TDs 460 feet or further from the section line. As a result, you have those green stranded areas. Through using longer laterals, you could drill across those areas. For example, on the upper right, you see there are 2 wells contemplated to sweep 2 miles worth of minerals. If you drilled a long lateral there, you could remove the stranded acreage in the middle of the section. Furthermore, if you built back into the adjoining acreage, you could land your horizontal closer to the section line and eliminate stranded acreage in that manner. We've done both of those things.
Thank you. And please describe this exhibit for the commissioners.
This is a submitted plat for one of the Cub Creek wells that shows the 460-foot setback from the section line. If you take that 460-foot setback on both the toe and the heel of the well and multiply it times 9 wells, that's 8,280 feet of horizontal that will not be drilled as contemplated by the current proposal. That's about the equivalent of 2 short horizontals or 1 mid-length horizontal that would be drilled in this particular area.
Could a boundary well capture and eliminate those reserves that are stranded?
The corridor that will be stranded on the east and west will be a northwest or north-south oriented corridor. So if you're going to drill a boundary well in those corridors, you'd be drilling a north-south well. We have 2 problems with that. Number 1, the north-south is not the preferred orientation, will not give you will not give you as much production as an east-west well, and it would be perpendicular to all the existing wells and potentially knock off those wells and reduce their performance as well. So we think it would be a very uneconomic venture to try to drill a well in those corridors, and so it's essentially stranded acreage that you'd never be able to get to until much later in life, potentially.
And has Kerr-McGee had experience with acreage similar to what we've seen today, actually stranding reserves?
We have, and we've had experience with trying to drill wells perpendicular to existing wells, and we've seen that interaction and seen it to be very detrimental.
Thank you. Moving to Exhibit K, please briefly describe this exhibit for the commission.
So in the black lines are the proposed wells that you've seen earlier this morning, the Cub Creek 9 horizontals. I've spoke to our drilling engineers, which again, our drilling department has drilled over 1,000 horizontals in the basin. They do not believe that you can land your horizontals at the 460 line with the lateral reaches that are proposed, and that you would need a bigger back build section. And so if you're actually going to land your heels at the 460 line in section 12, you would likely have to penetrate section 11 in the process. Otherwise, your heels will land further to the east and strand even more acreage.
And are there further safety risks or limitations as a result of that back build?
Generally, you'll probably be okay, but as you reach further and further to the north, I think the most northerly well is 1,700 feet from the surface location. To keep that build section in section 12 might require some pretty severe dog legs, and it's not something that we would typically do.
And to clarify, who owns the acreage underlying in splitting the section line between section 12 and section 11?
We're the leaseholder in section 11 as well.
All right, thank you. All right, briefly describe Exhibit L for the commission.
It's very similar to an exhibit you saw earlier. What's different here is we've highlighted the north-south corridors that would be stranded by the heels and toes of these wells. Those corridors amount to 149 acres of stranded minerals. They have also left a corridor that I did not depict on this image to the north. That's about a 560-foot wide corridor that would not be drilled either. So we believe this is significant waste.
And is that calculation a minimum or a maximum?
That's a minimum. If the heels landed further to the east, it could be larger.
All right. Briefly describe Exhibit M for the commissioners.
So this is one of Cub Creek's well plans. There's two parts to the image. Apologize if it's a little hard to pick out. To the lower left is the cross-sectional well plan for that Vale well. So you see the vertical section, the curved build section, and then the horizontal section. And in the upper right is the map view of that well going to the north. You can see a 1,700-foot lateral step out from the surface location, which we believe is a little extreme from what we would typically do on our own.
All right. Thank you. Moving to Exhibit N, you had briefly, or you had previously stated that Kerr-McGee has started the process of its integrated field development planning. Can you go into a little bit more detail on what Kerr-McGee has done to date?
Right. So here is our pipeline map specifically on this exhibit. I apologize, it's a little hard to read. The light gray lines are existing pipelines. It's a very extensive network that we've used to hook up all of our wells in the core of our operations. And in the red box is the general area in which we're speaking today. The dark lines are our proposed our proposed pipeline corridors. We have established right away for a pipeline to what we call our Wilson Ranch project, which is 2.5 sections to the south. We'll begin building pipelines, oil, water, and gas pipelines to that area, and we'll be drilling wells near the Northmore Acres neighborhoods in Berthoud. Our intent is always to try to bring infrastructure to the area before we drill the wells, not the other way around. We feel like that makes it a more efficient operation. So the majority of our planning in this area has been contemplating pipelines and how to get them into the locations before we drill the wells.
And you heard Mr. Berberick testify that Cub Creek has not set up a similar infrastructure plan for this area. So in your experience, approximately how much truck traffic will result from the 9 proposed wells that Cub Creek has planned with no takeaway capacity?
Based on what we've seen in the 2A and assumptions of the size of trucks and things of that nature, we estimate 14 oil trucks a day and 1 water truck a day. So on the order of 400 to 500 trucks per month.
And are you familiar with Cub Creek's proposed plans for surface facilities in this area?
They were not submitted as part of these exhibits, but we did pull them up as part of the 2A, so we have seen the surface layouts.
And based on your review of those surface layouts and in your experience, are there any concerns with Cub Creek's proposed tank locations or any other items on its surface facilities?
Well, I would start by saying that we commend Cub Creek for trying to shrink their footage or shrink their surface expression of the location. The 4-acre pad is pretty small, and it's located in the southwest corner. Those are all generally good things to do. Their wellhead to wellhead separation, I think, was 16 feet, which is about the minimum what we would do. We would generally leave a 30-foot gap between every other well, so that if we did need to come back in and put a rig on location, we wouldn't have to take wellheads off of adjacent wells. That's not contemplated in this surface, as well as the 24 oil tanks are only, from what we can tell, about 4 feet apart, which is pretty tight for doing any kind of repairs or if you needed to replace a tank in the future. And there was also no VRUs denoted on the plan. So we don't know what the plan is there.
Okay. So could you briefly describe the 2 scenarios we see in Exhibit O here?
This is really about economies of scale. So the top line 1 is a typical conventional approach to operations in Wattenberg. And then on the bottom is if you bring some additional technologies to bear, which usually only makes sense if you have a large contiguous acreage position. So Just very briefly going through, we could contemplate bringing electric power rigs, line power rigs. We've done that in the past. We would use our water on demand system here, so we wouldn't need water trucks during the drilling and completing operations. We'd probably be accessing more minerals from this location, so we'd probably have more wells on a small pad. If we have our pipeline facilities, which is our absolute intent here, we would be able to run, we'd be able to have a tankless battery operation here, so we would not have 24 oil tanks and 12 water tanks on location. We'd have a couple of small tanks that would help us with any surges we might take or any downtime we might need to have on the pipeline. That'd be it. And then we'd have pipelines dedicated to running those fluids to our processing facilities.
All right, thank you. To save time, I think we're going to go ahead and jump to Cub Creek's Exhibit 4. You heard Mr. Berberick testify that Cub Creek has not conducted seismic for these proposed lands. Do you have any concerns with regards to Cub Creek's development without seismic to date?
We do. We see seismic as being pretty critical, despite what was said earlier, not only to steering the wells, but to planning the wells. I'll point out the structure map on the left shows relatively flat contours to the north, but you'll notice they get tighter together to the south. That's a response to the Johnstown Fault, which is not depicted in this map. It's a relatively large fault that is deep-seated and comes up in this area. And there are a number of smaller associated faults that you would have trouble picking in logs that we can see in the seismic and map through here. And we would plan around those wells. Specifically in the Codell, the Codell is relatively thin, so we would definitely contemplate where those faults are located in our well plans.
And then we'll go ahead and jump to Cub Creek's Exhibit 8. Are you familiar with this exhibit?
I am. This is a type curve. We find it a little perplexing because it's a combination of Codell and Niobrara. We would definitely use separate type curves for each zone. One is a sandstone, one is a chalk. We believe that in our experience, they have different type curves.
Thank you. And we'll go ahead and we'll skip over Cub Creek's Exhibit 9 for now. We touched on that at some point or for quite some time during Cub Creek's case in chief. So moving just to Exhibit Q, could you just summarize the main points that are contained on this exhibit?
Yeah, we believe that we, as a primary majority interest owner in this drilling spacing unit, we believe that if we operated in this area, we could bring forth our integrated development plan with infrastructure. So our timing, and we'll hear a lot of questions about our plans. Our timing is really driven by our pipeline, which we are installing right now. We would install that first so that we can minimize our surface impact and then drill the wells after the fact. We realize that does not meet with their 12-month time frame, but we will have our first wells in the area drilled within the next 6 months down in Wilson Ranch. So we are moving from south to north, and we do have intentions, as you can see by our acreage position, to develop this area in a comprehensive manner.
And finally, as the majority working interest owner in these lands, has Cub Creek provided you with sufficient information to support this project?
We have not seen anything on the economic side. So we don't know what their well cost estimates are. Also, we saw some errors, as you guys pointed out, in the volumetric sheets that caused us to scratch our heads as well.
Thank you very much. Were exhibits E through Q created under your direction and control?
Yes.
And are exhibits E through Q true and accurate?
They are.
At this time, we would ask to move those exhibits into the record.
No objection.
So done.
And that concludes our directive, Mr. Trigestad. If there are questions or if Cub Creek has any cross.
You want to hear cross first?
Yes, please.
Cross-examination, please.
Me.
Mr.
I'm sorry, I
Willis.
apologize. I was looking at Mr. King. I saw him.
I've made that
light
mistake
up.
before as well.
I was going to ask Ms. Fulcher if I could grab my pen back.
Oh,
The laser pointer.
thank you.
Mr. Turkstad, I'd like to talk about the right portion of this exhibit. Could you explain to me what that demonstrates?
It demonstrates how we would drill our short laterals all the way to the section line, as well as having heels that go to the section line and eliminate the stranded reservoir footage. So the color of the wells just simply ties to the pad from which they come.
I see. So you button hook on both sides,
Yes.
countering sides, to try to stimulate the entire area of the reservoir.
That's correct.
Is that right? Okay. So in looking at this acreage, just going to go to slide B. You could ostensibly do the same thing, could you not? I mean, if these wells were drilled out and built, you then could come in with Rule 318A, and you could do the same thing, casting your wells to the west. Is that true?
That would be one scenario.
Okay.
Yes. If we did do that,
I'm sorry, about building out these S wells to where your so Cub Creek would come in, obviously, and they would have their surface location about here where the pointer is, and they would build their wells out and they would hopefully stimulate from where this starts here all the way to the east, to the toe of each horizontal well, right? I mean, that's what I'm picking up from that schematic. And my question to you is, could you do the same thing then in building wells that do the same thing but go the opposing direction to where this 460 foot setback that you're concerned with, you could stimulate that reservoir with your own wells that trend to the west?
you could. It would be much more beneficial to plan them at the same time for a couple of reasons. One is anti-collision. If you have wells that are passing by one another, you might need to adjust one versus the other in order to have them fit in a safe manner.
Okay, but you do that. It's possible.
I'm not sure that we've ever drilled a surface location later that button hook, to use your terms, button hooked through existing wells, like heels to heels like that. I don't think that we've ever done that.
But that's kind of what you're doing, except maybe not in the same time frame in slide G.
It's a big difference. We're doing it at the same time so that you can plan the wells together and then you can complete the wells together. So a big risk would be that if you came in later, drilled wells in, as you mentioned, and then completed them, you could adversely impact the existing producing wells that head to the east.
But that's how development occurs in the GWA all the time, though, does it not now?
Not that I'm aware of in terms of wells hooking between each other.
There's always the possibility there's going to be communication between wells when you're drilling in close proximity.
Yes, and we can try to manage that, but it often requires shutting in wells and losing production.
Okay, that's fine. And so, but once again, you could do this under the 318A rule. You could propose wells that go over a mile, then and build out to the west.
It wouldn't be our...
Okay, it wouldn't be ideal, but it's possible.
It wouldn't be our ideal.
No further cross.
I think we can do a redirect.
Now we can.
Jill?
We learned that, didn't we, in year
Thank
2
you.
or something?
Ms. Fulcher, you have about 3 minutes.
All right, I have one last question for Mr. Trigestad, and then if there are commissioner questions. Just for purposes of clarification, even in this scenario that Mr. Willis just proposed, would that require a second surface location?
Yes, it would.
And to clarify, that would not be a scenario that Kerr-McGee has ever opted for, drilling after.
It's not, the whole point of having integrated planning is to avoid situations just like this.
All right, thank you.
Okay, thank you.
Mr. Chairman.
Commissioner King.
You've testified about an integrated plan, a comprehensive plan. Is there any plan where Anadarko, Kerr-McGee would develop the areas surrounding the Cub Creek holding and not be back here requesting a pooling order?
I guess I didn't understand the question, but we definitely would intend to drill wells in this area.
That's not what I'm asking.
Okay.
What we've been given is the dilemma with what Cub Creek is proposing. According to your testimony, there would be at the toe and the heel and on the north side stranded minerals.
Yes.
What you're proposing, if we deny this, what concerns me is we have the potential to strand Cub Creek's mineral interest.
Yeah.
I find this untenable, and I'm asking you to provide me assurance, number one, that you will drill, and number two, you're going to do it in a relatively timely manner so these mineral owners will get the return on their investment.
Yes, and you can look at other wells that we've drilled recently and see that we do pull in quarter section owners quite frequently. So we don't have any objection to, or we would not intentionally strand another operator by shortening our wells and leaving them at the section line.
That's not, I'm facing a frustration here from a planning purpose because Anadarko Kerr-McGee is looking at Anadarko Kerr-McGee and you're trying a maximization effort. I'm looking from the perspective of an optimization effort, which means when you know that one of the little white guys can come in and totally blow up your plans, I'm frustrated that you guys didn't go ahead and start capturing these people early on to say, we're not going to go ahead and strand you and make it uneconomic and not in your best interest. You're the big guys. Unfortunately, you can't just worry about yourself and development. You got to worry about the smaller companies. And I'm not seeing any evidence yet that you are worried about them. I don't see any concrete plan that's not going to go ahead and present us this problem down the road with the other little white blocks within your blue. And that's what we face. We have an obligation to include everybody and at the same time balance that with the public's best interest. I'm not seeing it right now. I'm hearing a lot, but I'm not seeing it. And there's my frustration.
I understand. What I can tell you is that our planning process takes, it's about a year between when we actually engage in the planning to when we would be ready to submit permits. And we're not at that point here. We do have a huge acreage position that we're working all the way around the basin, and we do these kind of operations in other areas. We will do that when we get here. As I mentioned, we're about 2.5 miles from our most northerly part of our core development, and we're working our way this way. And I believe that the pipeline that we're bringing forth shows that is our intent.
You're missing the business risk. The business risk is what we're facing today. That while you guys are going ahead and doing a nice, slow Anadarko plan, we've got other interests that can go a lot faster. And they're not comfortable that they're going to be included in some reasonable balanced time frame that's going to go ahead and maximize their interests also. That's the problem that we have. I understand a big company planning process, but if there are possibilities that that planning process is going to go ahead and be stopped because of situations like this, and the planning process isn't working. I mean, we've got to go ahead and consider all the little white blocks. And right now we're hearing things, but we're not seeing things. There's the issue.
I would also interject that it's important to consider the efficiency as well. So, we believe that if we're allowed to continue with our planning operations, which are robust and would bring development here in the next couple of years, that we would have a much more efficient operation and to have less surface impact, be less impactful to the people of Johnstown.
May I ask
Go right ahead.
a couple of comments that potentially factor into analysis and decision on this? One is there seems to be a lot of elasticity around the timing about when we get here. I've never heard, well, we do integrated planning, we've started the process. I haven't heard a by when yet. Like January 1, 2016, we expect to bring a line in here. So that leaves me with some concern. I'm left with a bit of a background conversation of a similar discussion in a different state in which there was spacing issues discussed in an area which is pretty limited development, because I looked here and based on the website, there's very few horizontal wells drilled within this area right now. So you said you drilled horizontal wells in the area. Well, the area could be as near as I can tell, at least 6 or 8 miles away. So there's some issues around that. So there's limited development on the horizontal side. In the other state, there were surface access issues, which you've pointed out here also. And at the end of the day, there was a company that submitted a global development plan for long laterals, and Anadarko came in and argued, said, no, we should do it on short laterals. And near as I could tell is because it didn't fit with your timing. So that leaves me a little frustrated with this specific case as it comes here. To this specific case, if we can go back to the exhibit, which showed the button hook wells.
That was G.
Yeah, it's different on mine, sir.
Oh, sorry.
That one. So if you look on the right, that's short laterals developed in 2 sections. What I see is 4 well pads. So now let's go back to, is that, you confirm that? There are 4 well sites, 4 well
Yes.
pads. Okay. So let's go back to the one that was up there previously, that one. And Mr. Willis alluded to the fact that you could potentially button hook here. And right now, Cub Creek is only proposing 1 well pad. So if we're going to do 1 mile laterals on both sides, there's still 3 more pads potentially available to you here. What I'm struggling with is that they've accelerated this.
Mm-hmm.
You talked about anti-collision issues. Is there some reason why the 2 companies couldn't sit down today and plan out, okay, we're going to lay out Anadarko's laterals going this way or going this way, and we can plan where those other surface locations might be so we can do the anti-collision planning today? Is there any technical reason why you could not plan this development a bit ahead of schedule with them?
No, there's not. We would have the timing be driven by the infrastructure though. So we want to continue to build our infrastructure up here so that we can minimize our facilities. We've never said that we wouldn't work together with Cub Creek to come up with a planning or a plan that most efficiently develops both of our minerals in a timely manner. We've never said that. What we said is we weren't able to commit to these wells within a year, because we believe that within the next 2 years or 3 years, we will have pipeline in this area that will minimize the surface impact.
So is there any reason what would preclude the ability to potentially tie these wells into that system? Which I had a small question, is it who's the gas out of this area? Is this dedicated to Kerr-McGee, or is it, do you know?
Most of our minerals, as I understand it, are dedicated to us.
But what about Cub Creek's?
I do not know that one off the top of my head. I'm sorry.
So, I mean, notionally, if it's potentially dedicated to Anadarko to gather it, then you're going to have to hook them in anyway. So would there be any reason why, when you get here, why you couldn't tie these wells in, that facility could be taken away? You know, granted, they've invested in a bunch of tanks, but they can pick them up and haul them somewhere else.
Right.
Is there no reason why you couldn't tie that into your whole integrated development plan when it comes through here?
It's a matter of when would most of the production occur, and most of the production occurs up front, so all the benefit is up front. So we would want to have our oil pipeline here as well to gather and bring it to our facilities.
And when does that oil pipeline get here?
I couldn't speculate to that because we would need to secure the right of way, and I don't believe that it's been secured.
So we all do sort of risk analysis all the time. How about a range, like within 1 year to 3 years?
Something along that line, yes.
Okay.
And we have minerals to the north of here as well, and part of our pipeline development is to get pipeline all the way further to the north, up near where we drilled wells earlier this year in our Miracle Encore area. So we do, I mean, this is part of a larger area. We're not targeting this specific pad for our pipeline, but it's in an opportune area in that regard.
Okay. Another question, and you mentioned, testified several times about longer laterals being more efficient.
Mm-hmm.
I can certainly understand that potentially from surface impact, because in the case where you were against long laterals, the other company was testifying that it was more efficient to do long laterals. Makes sense, but what was missing for me is, have you done analysis on well performance that says, I get on an ultimate recovery basis,
Mm-hmm.
I get more recovery from longer laterals as opposed to shorter? Because there is some discussion around and concern about with these longer laterals that you lose production efficiency out at the toes. And at the end of the day, you don't get any better recovery out of a 2 mile lateral as opposed to 2 1 mile laterals. So that was sort of missing for me, is that there wasn't anything that said, here's a decline curve from a bunch of 10,000 foot laterals. Here's one from 4,500 foot laterals. Here's the improvement overall on a recovery factor basis for this particular area for those wells. And it's probably an unfair question because you don't have a lot of wells out here.
I would say that we're objecting to the proposal that was made here, but I will answer your question, and that is, we do see a minor degradation in the overall EUR on a longer well, but it's very, very minor, and we feel like it's offset by smaller surface disturbance and lower cost in drilling and completing the wells in the first place.
Fair enough.
Questions from commissioners? Okay. Is that your last witness?
We're
I
basically
forgot.
out of time, so we'll stop. I mean, we did ask for.
You got 3 minutes.
You have another.
Well, I have a closing, which will be longer than 3 minutes.
Okay, then, where are we going to move to next? Staff presentation?
If the commission would like to hear from staff, you may.
We're pretty close to the noon hour. And so, Ms. Murphy, I don't know if we would want to break for lunch and conclude this, because it appears to me this may take another half hour, 45 minutes to conclude, but I don't know.
Mr. Chairman, I have a quick question for either Jake or one of our lawyers here, and that is what, under the statute, the pooling statute, what are the appropriate considerations for us to weigh? The traffic, the ability to minimize footprint, those kinds of things, or is it simply related to the efficient removal and not stranding minerals? A little primer on what goes into a pooling request and what we can consider would be helpful.
We'd love to address that on closing when we get to it.
With respect to spacing, I mean, I can read the statute for you. You're concerned about drilling too many wells. Is the spacing unit too small? Is it going to efficiently recover the reserves? I think all of the subjects, I haven't heard anything that is like off topic. Everything that Kerr-McGee is addressing in terms of the surface footprint and all those sorts of things, as well as the Cub Creek. Everything that has been offered today is within the scope of your consideration, and there's not some weird outlier factual issue that's been presented.
So the benefit of pipelines as opposed to truck traffic goes to the efficient nature of it, so that's fair game as well.
And public health, safety, and welfare. Certainly. Thanks.
Chairman, to address your question, we have a working lunch scheduled at 12:30, so if there's an opportunity to resolve this before that, I think that would be a more efficient use of our time. Yes, sir.
Thank you. All right, then. Commissioners care to hear staff's point of view on this?
Absolutely.
Yes, I would.
Okay. Commissioner would like
Okay.
staff's presentation, please.
Thank you. Permitting manager Jane Stanzik is going to give staff's presentation. Yeah, can we borrow the
Sure.
Task.
How do you wash your right arm in the shower when you got a bag over this thing?
Oh, these are all the same. Nope, it's mine. Good morning. I'm Jane Stanzik. I'm the manager of the Permitting and Technical Services Group. And I have some slides, except you've pretty much seen all the things I had put together, but I'd like to walk through it for you anyway. Thank you. Here's the diagram you've seen that shows the acreage position in the north half of the section 12. This is within the greater Wattenberg area that's been mentioned previously. That's subject to Rule 318 Big A. Here's just a summary of Cub Creek's proposal. They would like to create a 320-acre drilling and spacing unit to allow them to drill 9 horizontal wells. And there's the location of the permits that they have submitted. This is the red outline is the 320-acre unit. Here's another one you've already seen, just shows Kerr-McGee's acreage position in the vicinity of the application lands. And everyone has already mentioned that the current development number of oil and gas wells in this area is pretty low. There's limited horizontal wells, and this just shows the applications and a little bit of a color code. Blue lines are pending applications that have been submitted and are currently being reviewed by staff. So you can see these are Cub Creek's submitted applications for 9 horizontal wells. The green lines are approved permits, and any purple lines are wells that have actually been drilled. And of course, the yellow circles are the surface locations of producing wells. Again, this is what folks have already talked about, that there's limited surface development in the area that allows for additional surface locations. So here's the northeast quarter of Section 12 that does have surface development on it, but you can see that for the most part, the surrounding lands that is where Anadarko owns minerals is currently farmland, so that there's not a severe restriction for where they could put additional surface locations other than the one that Cub Creek has proposed right here to develop their acreage. And this is an example of another area, it's a few miles away, where there's extensive horizontal development, which doesn't exist near the application lands. And this is primarily an area developed by Kerr-McGee and Encana. The only Encana wells are here in this eastern half of Section 28, and then all of the horizontal wells here in Section 34. The rest of these wells are Kerr-McGee's wells. These blue ones, of course, are submitted applications currently in process being reviewed by staff. All these green ones are approved permits, and then again, the purple ones are the horizontal wells that have already been drilled. And right here, this illustrates what Kerr-McGee was explaining their current method of operation, as do these green ones, where they have a surface location, they back build away from where they're going to develop, and then turn and drill a maximized length through their acreage. And you can see these green ones are doing that too. So a well drilled from here goes this way and then comes south to an endpoint here. Unfortunately, I clipped this right at the surface location, but these wells are being drilled from a surface location here. They would back build this way and then drill north. So the bottom hole locations, these are not 2-mile laterals. This is a 1-mile lateral that ends here, and these are 1-mile laterals that end here. And the way this is accomplished in terms of spacing is with using the wellbore spacing units that are provided for with Rule 318 Big A for the greater Wattenberg area. So in fact, this whole area would have a number of overlapping wellbore spacing units that prevent any stranding of any lands and maximum recovery. And that pretty much is the basis of my analysis that that the Cub Creek Drilling and Spacing Unit, yes, it has setbacks, it has a unit boundary, but because it's in the Wattenberg area, there can be any number of overlapping wellbore spacing units developed around it, drilling what are, we call boundary wells. That's what they were called when it was mostly vertical and directional. Now they're just horizontal wells that are drilled and drilled using a wellbore spacing unit that allows you to overlap a drilling and spacing unit. So my analysis is that what they're proposing complies with the Conservation Act and with our rules. It's consistent with the current development practices. They did attempt to utilize the 318 capital A wellbore spacing units, but as Kerr-McGee explained, they objected, and that's according to the rule. The wellbore units cannot be created over the opposition of another mineral owner within it. And I think that the flexibility of the wellbore spacing units mean that there would not be stranded minerals in this case. Any questions?
Commissioners? Question?
When were the first producing wells drilled north-south in this area? Has it been that long ago? Do you remember?
Oh, I don't know.
You don't know.
I didn't look.
Okay, no questions?
That's it?
Yeah, we have some time remaining for each of these parties to at least make a closing statement or.
That's where we're at here.
Sure. There's also an opportunity for Cub Creek to rebut.
Section 12.
Cub Creek, you have about 13 minutes left.
I think we'll waive rebuttal. So we're at closing. Thank you, ladies and gentlemen. Thank you for your attention. Certainly my client has noted it and certainly appreciates your considered grasp of the issue as well as your very probative questions to both parties in this case. From my perspective, from Cub Creek's perspective, this is, a case of Cub Creek bringing an application to develop its lands. They've been attempting to do this since they acquired the leasehold back in October of last year. They expend the capital. They negotiate for a surface use agreement. That also comes into the capital equation. They're looking for a return on their investment. They've attempted to engage Kerr-McGee over this issue over the time that they've owned the lease to see if they can do it collaboratively. And basically, it hasn't worked, mostly because of the time frame involved here, if not other things. But the time frame appears to be very critical, and it's critical to my client too, because if you look at the statute and you see the all-encompassing doctrine of waste, from my client's perspective, this is an economic waste issue for us. We're not able to get to our capital. We want to do it. We want to start producing these wells. We want to get a rate of return on our investment. That's what we're in the business for, and that's what we want to do, and that's why we pursued this application in front of you today. We haven't, we certainly haven't been trying to, and we haven't ignored Kerr-McGee at all. We've been trying to bring them into the circle with us so we can get this development underway, but it squarely has not worked. And so we have the ability to operate our own wells. We're a mineral interest owner, and we're seeking your permission to do that. Basically, we've got APDs in queue right now. We've negotiated the SUA. We're going to do what we can to try to bring this to fruition sooner rather than later, certainly in a shorter period of time than what we've heard Kerr-McGee is anticipating development here. I don't believe evidence supports that they've got any plan on doing this in the near future or distant future. It's just, a plan out there that they talk about as they work around the basin. But once again, it's important to my client that you consider this today, that they get approval of the application today, that they get permission then to start developing these lands. That's where we're at. So, once again, I appreciate your attention and your attentiveness. And we request the commissioners deliberate this issue certainly and approve the application as presented over the objection of Kerr-McGee. Thank you.
Mr. Chairman, thank you very much, members of the commission. We disagree with a lot of the ways things have moved forward here. First of all, a couple minor points, but it's fundamental that in a spacing application, this isn't pooling, in a spacing application, 30-60-116 says that you must show efficient and economic drainage of the reserves. Okay, that's fundamental. Assistant Attorney General can confirm that. On the economic side, it's their burden to show. We got no evidence, no price decks, no gas gathering costs, no water transportation costs, no water injection costs, no oil transport costs. $40 barrel of oil out there. We're not even sure this is an economic project, but remember, in a spacing application, you have to show efficient and economic drainage. So that was the motion I was going to make at the close of their case. We haven't seen that evidence. I've never presented a spacing application where you haven't said, okay, here's our price decks, here's what Wells Fargo's using, here's what the strip price is, here's how it's economic. So that wasn't done. So fundamentally there, I think we've got a flaw in the application and the presentation. Number two, from our point of view, this is still a mineral trespass. Now I know that in many situations when a pooling event happens, how many times do people come up and say, no, that's a trespass, I don't want to be pooled? When we drafted Rule 318A, when we talked about that earlier as an option, Tom Kerr and, well, we put in there very clearly that one of the objections that someone can make on a 318A well, and the Assistant Attorney General knows this, is if you're not an owner under that well. So all this talk about let's drill a 318A well, well, an owner can make an objection. Kerr-McGee is the majority working interest owner in this field. The reason I would submit that this is submitted as a drilling and spacing unit is that obviously, and we own the majority interest here, Kerr-McGee, and they would be able to object those wellbore spacing units. So those are two things. The third thing on the timing, they have been talking to Johnstown for a long time, have had series of meetings with Cub Creek. Their leases are HBP'd. I know they just acquired them. I know they were able to buy them within a city, but they're held by production. So whether it's 1 year or 2 years, it's not going to make a big difference in terms of holding their leasehold. Number three, your job. And the way I always think of this is it's a three-legged stool, to answer Director King's question. What do you decide on a spacing application? Number one, okay, does it protect correlative rights? I can assure you, and Mr. Triggerstad said it, they have no intention of stranding these reserves. When these wells are drilled by either party, this unit will be incorporated. I can guarantee that. We are not going to strand these reserves, and we're going to make sure that that doesn't happen. So on the correlative rights, they'll be protected. Number two, on waste. We heard all the evidence of how this could be done better so we don't have those stranded reserves. The application in front of you strands those 460 feet on each side and maybe more. So this does prevent waste. The final leg of that stool, in addition to prevention of waste and protection of correlative rights, is everything has to happen in a manner to protect health, safety, welfare, and the environment. And it may sound strange for me to be arguing this, but the bottom line is that there are better ways to do it. We all know it. We shouldn't be in a rush. Let's do it right. Let's build those water pipelines. Let's build those oil pipelines. Let's work with Johnstown. Let's get a plan that works for the whole area, get rid of the truck traffic, and work together with the operators to try to get this done. So in our view, there's no rush. Those three things you have to balance. In my view, the balance is towards protection of health, safety, and welfare and doing this right. Thank you.
Thank you. According to my sheet, you have a rebuttal closing statement.
You know, I do have a rebuttal, and I think I have abundant time to do it. I just have a couple remarks. And when I look at the hearings officer recommendation, which I know has been in your packet, and you were able to look through that, I think some great things are incorporated into that writing. I think it's very considered. I think their assessment that our plan, our application comports with the Oil and Gas Act is exactly right, and the rules that you've created under the Oil and Gas Act. We haven't cut any corners. We haven't done anything wrong. We've given this consideration, as staff has. When we build these wells out, any insinuation that we can't do it right or better than perhaps what Kerr-McGee does is wrong, because what's in front of you right now is an operator that has the ability and the experience to do this. And you know, they have the investment in their property, and they're looking for an opportunity to get that investment out to meet their expectations as to why they actually get involved in the oil and gas industry in this state. So, once again, it's just important that you take those into mind. We don't have a showing. One thing I did want to respond to was Mr. Wozniak's allegation that we haven't made an economical showing. My engineer, Mr. Peterson, did talk about the economics, that he ran economics, that they were positive. You don't have to know anything more than that. And we're going to be the ones that are going to be building out these wells. So you can rest assured that we're going to do it in an economical fashion and to protect our investment. So thank you. Nothing further.
Okay, Ms. Murphy, I'd like to close the record unless you slap my hands.
Sir, I will not.
Okay, the record's closed. Thank you all very much for very compelling arguments. Sorry, Enrique. Commissioners, it says here you are going to deliberate. As I said, I found both sides to present very compelling arguments. I really have hoped for, what's it been now, 8 years, that we might have some kind of like planning involved in the process. And we've heard from the protestant that they have a long-range plan. And the key word for me there that I keep throwing around in my head is long. And how that impacts, how that figures into this. So I'm struggling. But I'm sure Commissioner Allward or Benton, somebody will help me.
Well, let me comment and perhaps it'll draw out some more conversations. As I listen to this, it sort of gets down to me for trucks versus time value of money. So these folks have invested. Granted, they spent money that's held by production. I work for a company that's used that to plan its own development on some things out on the West Slope, so we can manage that development. So that's something that you have to consider. But the time value of money is a concern for a smaller operator. They need to go and develop their minerals. They have mineral owners who have written letters saying, we support the development of this. I'm definitely concerned about not actually being a numbers guy, not actually seeing the economics and being presented with that calculation. I mean, Mr. Peterson is a registered professional engineer. He's certainly not going to perjure himself in front of this group by saying they're economic and they turn out not to be. So I'm going to have to be confident, and it may be something that we ask, or I may ask and say before we go forward, is that we get to see copies of those economics. There's a pooling risk that as Commissioner King presented, we have no guarantees. There's nothing in a piece of paper. There's an agreement that says we will pool this acreage when we go through and develop this, and we will do this to the benefit of all. I was very concerned that when I think somewhere along the line that Cup Creek asked Anadarko, as my understanding, asked Anadarko about getting a look at their seismic. Why would they not share that? To me, it points to a larger operator not cooperating with a smaller operator. And also, I think Commissioner Craig brought that up. It seems like it's great to go talk to the towns, but when you've got a lot of acreage out there that's leased by smaller operators, and it's not just Cup Creek, and you're the 800-pound gorilla in the room, when you want to go talk to those small operators about your comprehensive development plan and get them on board with that. And that, to me, talks to that sort of how you do the efficient and economic piece of this development, is that it seems like it needs to be more cooperation. And at the end of the day, we're asked to make a difficult decision between drilling now versus drilling later, and trucks versus time value of money. And again, I think Commissioner King said at one point, you're asking us to be Solomon, and it's not a fun place to be. And those are my comments.
Commissioner King.
Thank you, Mr. Chairman. I continue to find these cases problematic, to say the least. And I don't think the rules as were developed have been, the development of the technology through the horizontal has placed us in a continuing and more uncomfortable place every time we take one of these things up. I'm not even convinced that necessarily the statute, when it was developed, contemplated anything like what we're talking here. But I do feel that based on what the statute lays out and what is in front of us, that the request should be granted. And I'm inclined to make that motion at the appropriate point. Having said that, I don't like these cases. And I hope every operator understands that when they come in front of us with these, they are asking the government to pick winners and losers. And that is not something I think any of us believe we should be doing. But that's what the statute charges us with, and a strict application of the standards in front of us, I think, justifies granting the motion.
Commissioner Allward.
Thank you, Mr. Chair. A point that Mr. Wozniak brought up about the comprehensive development plans, I remember that part of the rulemaking in 2008, and it was actually the part that I was the most hopeful about, that we would, that rule would encourage that sort of long-term, large-scale planning that would grant a greater level of certainty to other stakeholders, to communities, as to what's going on in their vicinity. My greatest disappointment has been how little that process has been used, that we really haven't seen that sort of planning come before the staff, and especially in a comprehensive way. Sometimes with just one aspect gets developed and planned over a larger area or a larger time, but not in a comprehensive way. And I really am reluctant to take any action that discourages that. And so I'm feeling the same sort of quandary and frustration in how to work through this decision, because we need that comprehensive development plan. I think that's something that would lend a lot of assurance to communities that are currently very upset about when drilling is happening in their vicinity and that they don't know how to plan for it.
And I'll add that in support of that. If that was truly, we did have a comprehensive development plan, it would also help smaller leaseholders and smaller operators in that they're going to be able to work with the larger ones on a systematic development that gives everybody value. So it's not just the communities, it's also the small operators, small leaseholders.
Commissioner Craig.
Just as a comment on this, I mean, I definitely prefer a comprehensive plan of development. The biggest risk to what we're seeing today is the fact that the smaller operators can come in here with the requests that we're seeing today. Now, my recommendation, because I am leaning towards approving what we're seeing, is for the big guys to go ahead and do the incremental analysis, and on the basis of using a Wells Fargo forecast or whatever to prove to individuals like Cub Creek that they're going to be better off going with the large-scale plans economically than if they go out and go on their own. Where's the advantage going to come from? The advantage is going to come from the risk in the drilling with the dog legs and not being able to make TD, the risk from the community because of the truck traffic, the additional burden of cost for having to do truck traffic. There is a business case to be made that it is in the smaller guys' best interest to go along with the big guys. But the big guys have got to go ahead and recognize that they've got to do the homework and they've got to get ahead of time. They've got to get there early. I agree. You got to work with the community, but when you're facing a risk that these guys can come in and ask for a development ahead of time, that's a business risk where you're not going to get to do what you want to do. That should have been worked a long time ago, and the business case, the incremental economics, should have been done ahead of time. The risk model should have been done, and it hasn't been. There should have been a technical and financial discussion long before it got here about this. So I don't like doing this either. I really don't like having to do these little 320 acres. I think it was Commissioner Hawkins that said 640 minimum going forward, where here's another example where maybe 640s would have made things a lot easier. But guys, I hope that other companies, other large-scale companies out there are going to pay attention to this, but you got to go ahead and look early at the little white spots within your blue.
Mr. Chairman.
Commissioner Hawkins.
You know, I'm listening to the testimony today. I was really disappointed in what we saw in terms of the engineering analysis and the economic analysis. And I was disappointed that there really wasn't more testimony from Kerr-McGee against what was presented, because all they really said was, hey, this is a positive rate of return. And they didn't tell us how they even came up with that. So I think that's where the record is left, that it's a positive rate of return. I agree that one of my major concerns, and I've expressed to the commission before, is the possibility of having small stranded acreage. And I think having a more consistent spacing approach out here would definitely assist, you know, in eliminating that. But we don't have that right now. We have wellbore spacing units. And so looking at what's been proposed, it's in line with how the development of the field is undergoing. So I don't see any reason to deny them their application for spacing unit. I don't think it's necessarily the best way to go, and I think that there's a lot of advantages to long-term planning and minimizing, infrastructure or impacts to communities by optimizing the infrastructure. But in this case, I'm having a real difficulty saying that we shouldn't grant them their application.
Commissioner Holton. Maybe Mayor Holton, are you still on the phone? Maybe not.
Mr. Chairman, I think that Commissioner Holton is on the phone. I think there's about a 45-second delay between when we talk and he is hearing what we're saying and able to respond by phone. So let's give him a minute. I do have a text from Commissioner Holton. If we don't hear from him directly, or you don't hear from him because I asked him to speak to you via text, I can let you know where he is.
Okay, I guess it's, Chairman, he says, Chairman, I vote with Mike and his comments. He didn't mean vote right at that time, but he agreed with Mike and his comments. He'll vote just a little bit later. Okay. Thank you. Thank you, Mayor Holton. Okay, any other comments?
Is it possible to ask our attorney a question?
We can sure ask whether he'll answer.
You don't have to answer, but you know, there's this question that's brought up about the spacing application versus pooling and a mineral trespass. Can you help me understand?
Sure, I think
the difference between those two.
Let me back up and answer Director King's question also. I do agree with the three-legged stool analogy. I think that's a fair analogy to what's in front of you. I think what Mr. Wozniak was referring to is that on the north end of this spacing unit, there was some testimony that those minerals could be captured by virtue of a wellbore spacing unit. And I think what Mr. Wozniak is referring to is Kerr-McGee's ability to veto that wellbore spacing unit. because Kerr-McGee is not an owner in, I'm sorry, Cub Creek is not an owner in the western half of the unit to be established.
So it would just apply to the boundary well running across the top end?
Yes. Because once the lands are spaced, then they would be pooled.
Sorry.
There's also a gap at the east side of section 12,
Yes. East side and
presumably 460 feet there and potentially 460 feet
so
on the west
you
of
could
the adjoining
object from a
side.
standpoint of mineral trespass, but then on the other hand, you're also stranding minerals by objecting.
Right.
Okay.
Also correct.
Okay, any other comments, questions? Hearing none,
May I make a motion? Would that be okay?
I think it's okay with.
Okay. And I would, and actually I would defer this to Mr. King, but my request would be in the form of the motion that we do obtain copies of the economics that were run by Cub Creek in support of drilling these wells. Is that possible to request that and have that included?
You can request it, but it's irrelevant. If we vote and approve this, then whatever those documents are, it won't impact the fact that we have made this.
Never mind.
Then I move we approve the application.
We have a motion to approve the application of Cub Creek.
Second.
And a second. Any further discussion? All those in favor indicate by saying aye.
Aye.
Mayor Holton, Commissioner Holton, I will need a vote from you if you'd like to vote. I guess I'll get that by text.
We lost him. I don't know if he's, I think we lost him.
Okay, let's go ahead. Are there any nays? Okay. Actually, I'm going to vote nay. And you've already heard my reason for it. We'll just assume that we have a majority vote, that the application is granted.
Thank you. And 6 is a quorum?
Yeah.
Okay.
Can I ask a question? In future, can we require that we get to see economics? That has to be part of the packet so that we, from both sides, and we have a discussion? Because that's very, very important. And I just think that that's part of this stool concept, and I think we need to be talking about that.
I guess I'll check with council on that question.
I think the hearing officers hear you loud and clear, and they can make that a requirement of any, if you get to this point, you can certainly ask for it and see what you get.
And I think that's entirely appropriate. I also think it takes us further down the road where, you know, we're going to be analyzing rates of return and whether one makes more than the other, and determining and understanding that in the concept of mineral economics, reasonable people can differ, right? I mean, I just think this is going to continue to turn into a quagmire, and I keep coming back to it's incumbent upon operators to work this out themselves and not continue to bring these to us.
Mr. Chairman, may I?
Yes, sir.
Commissioner Holton has indicated his favorable vote. Second, perhaps if there's time later today, and I'm hoping there might be at the end of the day, the commission would entertain some guidance to staff about the issues that Commissioner Holton, that Commissioner Hawkins raised, that we have talked about for some time now. And that is, should we reconsider spacing in the GY in particular? I know staff would be happy to provide some input as to the continued viability of the 318A wellbore spacing units and whether they're ought to be a default spacing unit size. And so much of that was at play here today, obviously in different ways, and it was certainly at play with the KPK and CANA spacing hearings that you heard a couple of hearings ago. So particularly if operators seem unable to work these things out, having those things in place might facilitate that. So food for thought. I don't think staff is likely to move forward unilaterally without your kind of guidance.
Okay.
Thank you, Mr. Chair.
Thank you. Thank you to both of you folks for excellent presentation. At this time, I believe, if it's okay with Ms. Murphy, we are going to take a lunch break. We have been invited or have invited some folks for a working lunch. We'll follow that with a brief executive session and intend to reconvene at 2 p.m. Right here.
Right here.
Thank you.
During the lunch break, we'll go into executive session pursuant to the Open Meetings Act, 24-6402-3A2, in order to receive a status update regarding the Marilex versus COGCC litigation pending in the Denver County District Court, the issuance of LGD credentials to districts established under the Special Districts Act, and to receive advice concerning bankruptcy priority rules.
So moved.
We have a motion. Is there a second?
Second.
And a second. All those in favor indicate by saying aye.
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 Thank you very much.
Thank you, Council.